All right, good morning. Day 2 of the Blockchain Select Committee here in lovely Jackson, Wyoming. We had I think, great day yesterday, got a lot done. Today we're going to be talking about some data privacy, our special purpose depository institutions, and then we're going to have some discussion about artificial intelligence a little bit later, hear from the Division of Banking and right to repair laws, as well as FTC click to cancel discussion. I'd remind any attendees that if you're attending, please sign in so that we have availability of who you are and understand that you are here today. With that, let's go straight into our data privacy after Mr. Co-Chairman. Any quick comments or anything before we get rolling?
Good morning, everyone. It's a beautiful day. That's all.
All right. Good quick comments. Very concise. All right, let's go to data privacy. Come on up, Talise. We had a bill draft last session, and it was on data privacy government entities. This went through the process last year and made it through the Senate with no problem. We had some amendments based on some great feedback by stakeholders, sent it over to the House, and it went through committee over in the House side, and I think there were some little tweaks in amendments, and then it basically just didn't make it across the finish line because it did not have, it did not make the floor on committee of the whole. So it died on general file. I think this is an important bill, so we wanted to bring it back and hopefully work through it fairly quickly today. Unless there are major new concerns, we can just pass that back onto the session and take another shot at it. But with that, Talise, would you walk us through at high level the 26 LSO 12 data privacy entities?
Mr. Chairman, members of the committee, Talise Hansen, Staff Attorney LSO, presenting Bill Draft 26 LSO 12, data privacy government entities. So just a high-level overview. This bill draft prohibits government entities from purchasing, selling, trading, or transferring personal data without the express written consent of the natural person whom the personal data references, unless an exception applies. And then the bill lists 4 exceptions. Basically, a government entity may transfer personal data to another government entity, provided that the government entity complies with this article. A government entity may transfer personal data to a non-government entity contracted by the government entity to provide or assist with government services. A government entity may petition the elected governing person or body with authority over the government entity for a case-by-case exception, and a government entity may transfer personal data that is transferable pursuant to HIPAA or FERPA. The bill draft allows Wyoming residents to request copies of their personal data from any government entity maintaining it. It also allows Wyoming residents to object to the accuracy, completeness, pertinence, timeliness, relevance, retention, dissemination, or denial of access to the resident's personal data that is being maintained, and requires the government entity to investigate the validity of the objection. The bill draft requires government entities that collects or retains personal data to adopt, enforce, and maintain policies regarding the collection, access, retention, security, and use of personal data consistent with all laws. The bill draft prohibits government entities from collecting or maintaining more personal data than is reasonably necessary for the performance of the government entity's lawful functions. And it prohibits government entities from maintaining personal data for longer than 3 years without a written policy identifying the extended retention period and providing a reasonable justification for the extended retention period. And I'll stand for any questions.
Excellent. Thank you, Talise. Appreciate it. Any questions, committee? Questions? Anyone online? Questions? I know we've worked this before. No hands up for our committee. All right. Thank you, Talise. Appreciate the run through. So again, we've worked this during the last interim. We heard from a lot of our agencies, worked through some concerns that were raised. We do have 2 letters that are provided in our online materials. And we'll potentially hear from them in public comment. So I won't go into the letters at this point unless we don't hear from them. But with that, let's go into public comment. And do we have Mr. Lubin on Zoom at this point in time? All right, let's bring in Mr. Lubin. Great. How many others do we have online for this? Thank you.
Mr. Chairman,
Yes, Mr. Lubin, welcome. Please let us know who you are and try to keep comments down to around 5 minutes in the interest of time.
I will certainly do that. And first, I want to apologize for a little trouble with my connection. We just upgraded our computer systems and I'm having some trouble on my end. So with that, Mr. Chairman, may it please the committee, my name is William C. Lubin. I am the General Legal Counsel for the American Title Agency in Casper, Wyoming. We have an address of 315 West First here in Casper, 82601. I did submit some written materials to you for your review, as well as a potential proposed amendment for your consideration regarding this bill. And I'd like to start by saying I think the bill is very well intentioned. I'm certainly not in any disagreement with what you're trying to attempt to do here. But I do think there are some unintended consequences that may flow from it. And I merely want to bring those to your attention, and hopefully they can be addressed. Basically, I've been the general legal counsel here for 7 years, and obviously title insurance and the provision of that is very integral to the economy of Wyoming, banking institutions, owners and purchasers of real property. We have to be able to efficiently process requests for title insurance, especially on the lending side for banks, so loans can be made and the provision of our services. And in that regard, we rely heavily on our internet connections with the county clerk's offices, whereby we download information in order to build our title plant, which is required by law, in order to make sure that we deliver good and accurate title information to our customers. In this regard, that computer access really is imperative across the state for all the title companies that use this type of interface. The questions and the problems I have under the proposed bill is transfer is not defined. And consequently, transfer could very easily be interpreted by the county clerks in the state to mean that those computer access terminals that we have not be provided and be shut off. If that would happen, we'd be regulated going back to doing hand searches of the title records, transcribing that information basically by hand or photocopy, bringing that information back to our office, re-entering it into our computer. And I think the point here is that that doesn't just happen once in a real estate transaction. We update that materials continually during the transaction to make sure that title is good and merchantable that we do deliver. And so I think some consideration needs to be made, I would request, to allowing access by licensed and regulated title insurance companies and agents. We are highly regulated by the state through the insurance division, as well as the agents that deliver these services. In that regard, we're not like an organization that might want this information to put on the dark web or to use it for nefarious purposes. Again, this is really truly integral to the economy of the state of Wyoming. So that's my first point, and I think I addressed that in my materials that I provided. My second point is having practiced for over 40 years and being a very active litigant in civil and criminal litigation for that matter. I do have a concern about not necessarily a conflict, but how the proposed bill interfaces with the Wyoming Public Records Act. And although I go into some detail, basically the proposed bill expressly provides that other provisions of law should prevail for the release of public information. But however, when you go to the Public Records Act, it talks about releasing any information that's not otherwise privileged or confidential. And I would submit to the commission that the proposed statute really does make the information that an individual has their name on in public records a privileged matter and really confidential unless they release it. And consequently, in litigation and quiet title actions or any other action that would involve real property, such as boundary disputes, it may become impossible to obtain a copy or a certified copy of that document without the express permission of the individual who is referenced in that materials. I do quite a bit of quiet title action work, and in that regard, we rely on historic records. Many times individuals are deceased. There's no way to get consent from an individual in that circumstance. And so consequently, this could create some issues, and maybe the only way you could obtain the document for a court proceeding would be to subpoena the court clerk or the county clerk, excuse me, to bring that information. And then the court would probably have to seal it under the statute as proposed as a confidential document. I don't think that's very workable, and it's not really practical. And I think, if I may submit to the commission, I think those are two matters that really were not intended. And I think the intent of the proposed legislation really has a very good faith approach to a real problem that we have today with fraud and everything else that goes on especially in the real estate industry. We specifically have caught two instances where people have tried to sell vacant land by owners who were absentees, and we prevented that from happening. But without our digital access and being able to review these kind of records, that's going to become harder to do also. In short, I would submit that I did propose, if you look at my written materials, two proposed amendments for your consideration and perhaps reworking if you so desire. One would create an additional exception for licensed licensed title insurance companies and the agents across the state of Wyoming, which is a class in of itself because they are licensed. I think that's different than giving information to the general public. So I think that would survive any equal protection argument. And then also I added a clause to make, I guess, to clarify that public records would still be available by request for photocopies of the documents from the various county clerk offices across the state or the state. And I might add, the Department of Revenue has interface opportunities for their records, as well as the GIS system through the state for the statewide parcel viewer, all of which contain the personal names of individuals that title companies actually interface on a very regular basis. I hope you take my comments in good faith. I will ask you to review my materials. Should you have any further questions down the road, I'm more than happy to discuss those with you. And with that, I'd open up to any questions that you may have.
Mr. Lubin, thank you so much for the comments. Any questions, committee, for Mr. Lubin? Yeah. Leader Yen.
Mr. Chairman, thank you. Mr. Lubin, appreciate the comments, and I've been reading through your testimony, your written testimony as well. I'm loath to include a specific exception for title companies, but I do think that it might be worthwhile to recognize the Public Records Act in this bill and maybe give deference to certain things in it. Do you think it would be worthwhile just to say that this bill doesn't automatically make a record privileged and confidential for the Public Records Act alone?
Mr. Lubin, thoughts?
Mr. Chairman, based on my fair reading of the proposed bill, I do think that it makes the information privileged as to its release by any governmental entity without the express written permission of the individual who's referenced. So I do think it does create a privilege, and you may call it a limited privilege, but it's a limited privilege and makes that information, at least to that extent, confidential. And then when you look at the Public Records Act, it allows the release of any data which is otherwise not privileged or confidential. And so I think the two sections kind of run into each other, and it leaves a question as to whether or not that public access to the public records would be allowed by photocopy, facsimile, or otherwise. And so that is my honest reading of the provisions.
So, Mr. Chairman, I guess, Mr. Chairman,
Follow-up, yeah.
thank you, appreciate it. Mr. Lubin, I maybe my only thought is, do we need both of your recommended subsections or just the subsection 4 that you recommended?
Mr. Lubin?
Mr. Chairman, I think it could be approached either or both. I really would urge you to consider the III provision, again, because we are licensed and the title industry in Wyoming relies heavily on that internet or that digital access to these records. We're going to throw back 20, 30 years of the way we do business. When I started practicing law over 40 years ago, we did it by abstracts. We go to the courthouse, start with a patent, and handwrite every document all the way through to the current time. An abstract we prepared, and then I, as an attorney, would write a title opinion based on that abstract. Abstracts aren't used anymore. Everything is at light speed. Lending institutions want their information within a day. We try to turn our title work around within 24 hours to both banks, realtors, and other people who are trying to sell or purchase real property. This is a real question of time. If we have to go back to the old system, it's going to require a lot more people and a lot more time. And I do think it exposes the entire system to a higher error possibility in the delivery of our services. So I would urge the commission to consider both the amendments or a amendment of that, or what you might deem appropriate. But Mr. Chairman, in answer to the real question, either one or both would work. I think the Roman numeral 4 is really important based upon the conflict between, I shouldn't say it's a conflict, it's just how they go together. But I think it needs to be stated so it's clear how the Public Records Act should be applied.
Thank you, Mr. Lubin. Additional questions from Mr. Lubin? And I'll note, Mr. Lubin, and I don't know if you saw the discussion during the last interim, we did have discussions with title companies that led to discussions with clerks about whether this would or would not preclude access electronically, as you do right now as a title company, to those records, property records. And the conclusion from the clerks was that it would be just fine. That everything as written would appropriately allow access to existing public records, and that we didn't need an explicit carve-out. We're very reticent on this bill to provide explicit carve-outs. You can imagine that when we started down this path, I think every agency asked for an explicit carve-out, right? We're special, and we want to ensure that we don't have to follow this law, but everyone else should. And so we worked really hard to try and get to the point where we didn't have explicit carve-outs, but that we'd written it in a way that public records and public transactions that needed to take place were able to be taking place. And so with the clerks that we consulted with, they were comfortable that through the Public Records Act, they had access to the documents that we're discussing, and therefore you can have access electronically to them. So that point, which is the Romanet 3, based on that public testimony, seems to be taken care of. And I'll just note also that what it would take, even if a county clerk decided, no, this statute says that we can't give that out, that county clerk is the elected officer that would be responsible and capable of waiving a requirement under this by simply writing a letter that it's okay. So they would just publicly declare pursuant to, let's see, where's our exception? It is
Mr. Chairman, it's
Yep.
page 5, lines 16 through 22.
There we go. Thank you so much. Yes, page 5, lines 16 through 22. A government entity may petition the elected governing person or body with authority over the government entity for an exception to the subsection in a case-by-case basis, and then it lasts 2 years. So if for some reason a clerk didn't read it like the other clerks that we discussed with, a simple letter declaring that they were going to provide access to this would cover it. So it would at that point simply be if the clerk felt it was in order, and I would expect the clerk to feel it's in order. So as we worked through this last time, those were the two possible remedies that already exist. On the concerns about the public record, the and other things that aren't otherwise privileged, that's interesting language, and bringing those two together, I definitely see the concern that you're raising. The challenge is that the purpose of this document is to provide protections for things that don't have a legal justification for release. That's its point. So if you don't have justification for releasing a document, you don't release that document. So you would either need the written consent, you would need an elected official to say it's appropriate and will waive it, or you would need statute to point to say that this is something that should be released. And so my question back to you would be, what is an example of something that doesn't fall into one of those three categories that we need to have released? Because again, if there isn't a public purpose defined by statute for releasing information that's personally identifiable information about somebody, I guess I can't see why we want the Public Records Act to release that information about somebody.
Well, if I may, Mr. Chairman, the committee.
Mr. Lubin, thoughts?
Yes, sir. I
Yeah.
apologize. Am I coming through okay? I guess that's my first question.
You are, Mr. Lubin. We have a lag that leads to awkward conversation timing. So it's about a 1.5 second transition, and that's why we're experiencing what we're experiencing. So my apologies for that. It's just in the nature of the technology we're running. But please, yep, go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. Mr. Lubin, your video feed is also working. So, in case
Well, good.
you know.
Thank you. I was having some real issues on my end because of going to Windows 11. So thank you. In short, in your question, Mr. Chairman, the way the Public Records Act is structured is to make photocopies of public documents. And I see a difference of an individual coming to the clerk's office and requesting an in-person photocopy or a certified copy for a court proceeding versus someone who wants an access to all of the information that you have that could be used for nefarious purposes. And I think in asking each clerk for a written permission to get a document for a court proceeding simply is not workable or practical. I do think the way the Public Records Act is worded, though, or maybe a tweak could be done to it, but it does allow for copying or photocopying of documents, and perhaps that could be limited in that regard to not doing carte blanche digital release of the entire file. For instance, all of your records where they glean the information that they can use for illegal purposes. So I do think that it's not workable to, in the heat of litigation, you need a certified copy of a document, and a clerk says, gosh, what's your real justification? Or they don't agree with the justification to release the document. Now you're back into a court proceeding. So I do think that something needs to be looked at in this regard. As to your comments about the Romanet 3, I would just submit to the committee that an ounce of prevention is worth a pound of cure. And if it's clear that information can be released to title companies, we won't necessarily have a problem in the future. I don't know that we'd have a problem. I understand many of the clerks don't think they have a problem, but I do think the statute, the way it's worded, the word transfer by not being defined is broad enough that I think it could cause some concerns or problems, and it could concern. And those problems are going to really come up on the not the legislative side, but in courts of law and interpreting this proposed bill. So with those comments, I will submit it to the committee, and I appreciate your consideration of my comments. And thank you.
Thank you, Mr. Lubin. We appreciate your time and appreciate your input. Mr. Co-Chairman, question?
Thank you, Mr. Chairman. So as I'm thinking about these particular types of situations where you may encounter a hiccup with a county clerk, for example, do you think it would be appropriate or applicable to have some sort of temporary waiver of these particular protections on a case-by-case basis that could exist for your services?
Well, Mr. Chairman, that's what the 2-year letter basically does. It's exactly that. And then the legislature could decide whether we want to, whether we need to make it explicit if we run into problems.
Mr. Chairman.
Yep.
I'm thinking of it specifically to the services themselves and not on a time basis. so that it wouldn't time out, but rather on a particular instance, they could choose to waive that particular privacy right. But then after the business transaction has occurred, it would then go away. Are you saying that the bill already incorporates that?
It would allow for an up to 2-year exemption if the elected official that oversees those records wants to make an exception of pretty much any kind. They can do it. They just have to write it down and post publicly what they're doing. And the purpose for that is if you're going to disclose records that you don't believe you have the legal authority to disclose, you post that you're disclosing those records. And then it's not a forever thing. You've got 2 years up to, and then you have to post it again so that the public then once again understands that you don't see that you have legal authority to provide access to a record. You're doing it anyway. And as we know, the public is sensitive to privacy. And if it looks egregious, the public would have a chance to see it. And that would then enter into their decisions regarding election. Or again, if something comes up which is of concern and we missed it, then we have the opportunity to come back and say, oh, we missed that. You know, everyone made this public declaration, and obviously that needs to be public.
Thank you, Mr. Chairman.
Yep. Any other questions for Mr. Lubin at this time? Any other questions? Senator Crago, are you coming on for a question? Yes, you are. I see your hand up. Floor is yours, Senator.
Mr. Chairman, just a question for Mr. Lubin, and I guess my question is are we worried about the actual, for example, deeds, other recorded documents from the clerk's office falling under this particular proposed language, or are there some other documents that you're referencing that you're worried about and therefore needing the carve out?
Thank you,
Thank you,
Mr.
Senator.
Chairman.
Mr. Lubin, go ahead.
Yeah, Mr. Chairman, I think the real crux of the issue is with the records of the county clerk being the real estate records of mortgages, releases, the deed records all the way back to the United States patents and so forth. We do rely on other services. In short, the Wyoming Parcel Viewer, we look at that on occasion. And we also do access all the, if I may, most of the assessor's office and treasurer's office do have a portal that allows access to their records through a property search tool, and we do use those on a regular basis. However, the prime concern for us are the records of the county clerks, because those are the pristine records of the title and ownership of real property, and so that is our main thrust here.
Follow up, Senator.
Mr. Chairman, not really follow up for Mr. Lubin, but maybe for the members of the committee that were on this, that worked on this bill previously, because when we debated this bill, talked about it on the floor in the Senate, I guess I didn't really think about it, or probably didn't think wide enough. When we talk about personal data, are we including just, for example, every deed's going to have a name, address, etc.? Were we thinking that falls under the definition of personal data, or are we thinking it's more discrete than that? What was the intention of the committee as you were drafting this bill, Mr. Chairman?
So, Senator, on that, yes, it would be personal data, but my understanding through working it was, some personal data is explicitly allowed for transfer and for sharing as public records or in other capacities. So the way this bill is structured is, check, is it personal data? If yes, is there an authorization under law for it to be shared in some way? So whether that's transferred, sold, bought, or anything else, is that lawful? If no, then you don't do it. You can't do it if you don't have an explicit path to that release. So in conversation with my clerk and another clerk, there was a belief that they had the authority statutorily through Public Records Act to do that. Now, if not, and if Mr. Lubin is suggesting that the authority is not statutory, then it becomes a great question. Should it be statutory? Right? Because should the state of Wyoming be releasing personal data without the statutory authority to do so. And kind of the position of this bill is no, it shouldn't be doing that. Somebody should have debated that. The legislature should have decided, for example, that we should be releasing title information to title companies. That shouldn't just be asserted. It should be lawful. And so that was kind of where this comes from. And in conversation again with the clerks, we got to the point where I was comfortable that the data that Mr. Lubin needs, Mr. Lubin can continue to get. He would be able to certainly in my county after conversation with my clerk, but we didn't necessarily hear from all of the clerks. And again, we have a couple of catch-alls in there to ensure that if we've screwed something up, there is the immediate capacity for a remedy by an elected official. And part of the reason for that is that it's anticipated that we may have missed something. Any further questions, Senator? Okay.
No, thank you, Mr.
All
Chairman.
right. Any more questions for Mr. Lubin? Seeing none, thank you, Mr. Lubin. We appreciate your time, appreciate your testimony.
And Mr. Chairman and the committee, thank you for your consideration of my comments. Thank you.
All right. And other public testimony?
Mr. Chairman, we have Ms. Egan online and Mr. Marr would like to participate as well.
Okay, we've got Ms. Egan and then Mr. Marr. Sounds good. Ms. Egan, welcome. Let's try and keep comments to around 5 minutes and then we'll ask questions.
Okay, thank you, Chairman. Can you hear me okay?
Very loudly, actually, so we might adjust that a little bit. You are coming in loud and clear.
Okay, sorry.
Okay, the floor is yours.
Okay. Thank you
It's
very
not your
much.
fault, it's just the way it's going.
Thank you. Carrie Agan, resident, Buffalo resident and retired geoscientist. I'm speaking for myself and as a consumer. Sorry, I'll try to keep this short. So this bill is a valiant first effort, and I applaud you guys heartily for taking this on. This is an incredibly important topic. I would love to see more in there about data security, not just privacy, but also security. Sorry, I had my notes in a couple places. So I see an absence of 4 things, and I believe most of them have to do with security. One is what to do with the data after it's no longer needed. So I think there needs to be some time frame for retention built in there. And then as part and parcel of that, then also some type of assurance to the public or whoever's data it is, that data has been destroyed or removed from the system. I think there also needs to be a little bit more in the way of more teeth for holding agencies or officials accountable for not following the bill's provisions. And then a little bit, maybe more explanation on what recourse aggrieved individuals or entities may have. Now, I also have a whole explanation on how important it is for data privacy and data security, but I'm going to try to cut that short. Our data is being gathered in immense volumes, and our data is going to continue being gathered in immense volumes. That's what these AI/data centers are about. There's hundreds planned just for the United States, thousands for the entire world. And you know, you may think, well, I'm not doing anything wrong. You know, what's the big deal with somebody gathering my data? Well, the thing is, all of our data is going to be used as a carrot and stick. The amount of water you can use, the amount of meat you can buy, the amount of gasoline you can purchase for your vehicle to get to work is all going to start to be rationed. I know I sound like an alarmist, and that can't possibly happen here in the United States, but that is the trend. ESG scores or similar, whatever they decide to call it now, are already being put on folks' bank account statements, investment account statements, and even utility bills. You will be labeled according to your usage. For instance, here in Buffalo, the city decided on their own that they're going to install smart moderate meters. Well, the meter company, Metron Farnier's website, touts how our usages can be used to determine our ESG compliance and even compliance with watering restrictions. Now, that all sounds good and all that. I understand about watering restrictions. I don't think anybody has a major issue with that. But the point is that this will be used as a carrot and stick. All of our data. For instance, the Metron Farnier website, they show in a video how the use of 169 gallons of water in 1 week was labeled by their software as wasteful, when typical 4-person households use between 300, 400 gallons per day. So we are being labeled according to our usage, according to our data, according to everything we're doing. ESG and other unconstitutional restrictions are not coming. They're already here. Thus, the privacy and security of our data, especially digital data, is paramount. This bill, again, is a valiant effort, and I applaud all of your efforts to increase the data privacy and secure for everyone. However, you don't make any mention of how it's will affect, how it will apply, or if it will apply to private individuals or companies. So there's still a lot more to be done, but again, I applaud your efforts. Keep going. And I just want to remind you that our rights are paramount. All this digital gathering is actually violations of our Fourth Amendment rights. The Fourth Amendment, I'll just read it to you. It's very short. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So every effort that you guys make to ensure that our rights and your rights are upheld, I applaud, and I just say, good on you, keep going. Thank you. I'll stand for any questions.
Thank you, Ms. Agan. Appreciate it. Questions? Representative Filer.
Thanks, Mr. Chairman. Ms. Agan, on the data security side of it, you mentioned, I think on page 5, starting on line 8, at least in that paragraph, it does say any personal data transfer pursuant to this paragraph shall be returned or destroyed by the non-government entity once personal data is no longer necessary. Because I believe you got to, be able to release your data, and then once that's all done, it gets returned back to you or destroyed. I'm just wondering if that part right there would be sufficient on your data security side.
Thank you, Representative Filer. Anyone else have any questions? We'll stack up a couple of questions and then we'll allow Ms. Agan to offer some response. Go ahead, Representative Singh, quick question.
Thank you, Mr. Chairman. Quick question. So how much of a concern is it to you, Ms. Agan, that the services of data retention could be contracted out by the government? And do you think that the infrastructure is necessary for a centralized the holding of that information?
Thank you, Mr. Co-Chairman. Okay, back over to you for a quick response. Ms. Agan, go ahead.
Okay, thank you, Chairman. Representative Filer. So yes, thank you. That I did see that. There is still an issue with assurances that data has been removed or destroyed. So that piece, I think, still needs a little coverage. Thank you. Representative Yin, I apologize. I'm not remembering exactly what you asked. I apologize.
Thank you, Mr. Co-Chairman. Re-ask.
Thank you, Mr. Chairman and Ms. Agan. My question is, how much of a concern is it to you that the service of retaining any digital information could be contracted? And do you think the infrastructure is necessary to be held by the state itself?
Thank you. Go ahead, Ms. Agan.
Thank you, Chairman and Representative Singh. I apologize. I said Yin. That's an excellent question. I think contracting it out is not unreasonable, but then there would need to be some assurances between the state and the company that things are handled appropriately and that the individual's data who they're handling, that they also can know that their data has been removed or destroyed in an appropriate manner.
Thank you, Ms. Sagan. Appreciate that. Any further questions? Further questions? Seeing none, thank you, Ms. Sagan, for your testimony today. We appreciate you being here.
Thank you very much.
Let's go to Mr. Marr. Mr. Marr, welcome. Please tell us who you are once again and try and keep comments to less than 5 minutes. Thank you.
Hello. Can everyone hear me loudly and clearly and see me?
We can hear you. We can hear you clearly today.
Oh, great. Yeah, thank you very much. Brendan Marr, MIT Media Laboratory alumnus and a longstanding contributor to the discussions here. And also I've been involved in the working group for the Wyoming Digital Identity Act, which is relevant to our conversation here. I would like to bring to the attention to the committee two sections which I have concern about. And I would like to also say that I do actually concur with Ms. Egan, if I'm saying her name right, regarding security concerns. So those two sections would be the sections on 921-202, where it says all it's 921-202A Romanet 2 destroy any personal data transferred pursuant to this article, et cetera, et cetera. I think I have that right. The key point there is the wording is destroyed, which is problematic for the reasons that if you have data that is referenced on a blockchain, and most data will be referenced on a blockchain, whether it's encrypted or not, will raises a problem because you can't destroy stuff that's on a blockchain. You can destroy how it's accessed. You can destroy the keys, how it's encrypted. You can just do other things. Let's just say that. The other section, what I also have some concern about would be Romanet. The section 9, sorry, I'm wearing my other glasses. The section 921-203, where it says no government shall collect or maintain. The maintain wording there is problematic for the same exact reasons. And I would like to see also some references in it at some point, maybe not now, but at some point in an amendment in the future that references things such as zero knowledge proofs. Computational ways where we can understand information, know that somebody has an understanding of certain specific information without actually revealing what that information is. And I know that's a mind bender, and I won't get into it now unless somebody asks, but these are algorithms that are out there right now. And they're being deployed, they'll be deployed at a larger scale going forward. I'll take questions.
Thank you, Brendan. Appreciate the testimony. Any questions for Mr. Marr? Any questions? Seeing none, thank you, Mr. Marr.
Thank you.
All right. Any additional public testimony at this time in the room here? Come on up. Either of them is just fine. And you'll have to turn the microphone on. There's a green light when it goes on. So welcome, please introduce yourself. Welcome, the floor is yours.
Thank you. My name is Reed Reisner from Casper, Wyoming. I own Reisner Media and Omnivest Financial. So I'm here to talk about a couple things. So thank you, Mr. Chairman, and thank you, Representative Singh, for inviting me down to talk a little bit about data security, the TikTok acquisition, and most importantly, the Wyoming stablecoin, hopefully. TikTok is the largest data asset ever offered for sale. And I think this is relevant after hearing some of this testimony. With nearly 2 billion users, TikTok collects more behavioral, biometric, and consumer data than any other platform in history. If the US allows a platform to be controlled by a foreign adversary or an unregulated monopoly, we lose digital rights of an entire generation. So when we talk about data security, I think it needs to be a little bit layered here. So AI is already guarding the gates. Artificial intelligence should be used to monitor data in real time, not manipulate users, but flag real threats, fraud, breaches, and illegal activity, especially when we talk about blockchain technology. if we're going to allow a platform with integrations like the Wyoming stable token to be integrated into TikTok, we have to integrate an ethical American-controlled AI, hopefully in Wyoming. And we already have a lot of AI technology coming out of Laramie and quantum computing coming out of Laramie. And quantum computing threatens our existing encryption. So when we talk about encryption, within a few years, we believe 3 to 5 years, quantum systems will easily break the symmetric and asymmetric, so RSA and ECC encryptions that we currently use, and they're the backbone of our current internet security. And Wyoming must be the first, because of our stable token, we're the first government-backed stable token, to mandate post-quantum cryptographic standards for all digital infrastructure connected to U.S. consumer data. This includes all of our fintech technology that we're going to implement into TikTok. The layered defense is the future. So today's systems use 2 and 4 layer encryption. The future, at minimum, will require 3 and 5 layer post-quantum encryption, quantum key distribution, and AI behavioral monitoring. And I'll get into that in just a second. Security, identity authentication, and immutable audit trials. So TikTok must operate at a zero trust, multi-layered framework to protect American users, Wyoming users, and ensure state-level security integration.
1 second. Yep. Go ahead, Senator Nethercott.
Thank you, Mr. Chairman. Just a quick
You have a
question. Yeah, thank you. I'm just curious as to what Mr. Rasner is reading and how this connects to the bill in front of us right now. I know there's a recognition of Wyoming stable token and references to TikTok, but just what is Mr. Rasner reading and who produced the document that is being read?
Thank you, Senator Nethercott. Mr. Rasner, you want to respond to that real quick?
Mr. Chairman.
Yep,
So,
go ahead. Mr. Rasner, excuse me.
Perfect. Mr. Chairman, thank you. So I typed this myself. Thank you. And how does it relate to data? This is, if we're going to integrate Wyoming stable token into TikTok, we have to have data security on the blockchain that is backed by quantum computing and AI that monitors it in real time. So when we talk about quantum computing, and I can go off script if you'd like, in data security, that the AI will monitor real-time data security on any application through. So this bill, the AI will monitor your data and make sure there's no breaches in security is what we're doing. But when we talk about the stable token and running $1 trillion of assets through the Wyoming stable token, it produces $30 to $50 billion in revenue annually for the state of Wyoming. And when you look at biannual budgets of $11 billion currently, that's 3 to 5 times. So data security is paramount when we look at this size of transaction. So this is a concern of ours, protecting consumer data and ensuring that foreign adversaries can no longer breach that and consumer rights are upheld and no longer shared in nefarious ways.
Thank you. Please continue.
Sure. So to go into the stable token, if you'd like me to, we already know a lot about this, but really running it through Ethereum, Solana, Avalanche, our token is scalable, auditable, and programmable when we run it through the blockchain and completely protected through AI enhanced and quantum ready. So when we look at the infrastructure we're rolling out across several states, and we've spoken with South Dakota and several other states about this, and there's a lot of interest out there. What does that look like, and how do we integrate that into what we're currently talking about here with data security in your bills? And you have to have some sort of quantum advancement in AI technology through public-private partnerships. This is going to have to be part of what you're thinking about, because this is coming in the next 3 to 5 years. And when you look at what China is doing and the opportunity Wyoming has, they're not only in our rearview mirror, they're just right behind us, prepared to advance past us. So the opportunity for Wyoming, when we're talking about data security, is actually massive right now with these public-private partnerships in advancing quantum computing and AI. This will be similar to DARPA and the creation of the internet. or the race to the moon to advance us past and be the #1 global player. And Wyoming truly is leading the way right now. And I think the legislator just needs to truly take a 1,000-foot view and look at these advancements in those fields if you're going to have digital security as a topic. Thank you.
Excellent. Thank you, Mr. Reisner. Appreciate that. Any questions for Mr. Reisner? Go ahead. We'll start over with Representative Filer and then come back to Mr. Co-Chairman.
Thanks, Mr. Chairman. I think I was just trying to piggyback on Senator Nethercott, seeing what this had to do with the bill. I think the part of it is just the government entity side of it. So if we are talking about doing the stable token, that is definitely a government entity. And I think we really do need to make sure we encompass those types of securities too.
Mhm.
It's just more of a statement, Mr. Chairman.
Oh, thank you. Appreciate it. Mr. Co-Chairman.
Thank you, Mr. Chairman, and Mr. Reisner for being here today. I don't think this committee has really talked that much about the upcoming developments in technology and the vulnerabilities that our state infrastructure have to more advanced computing capabilities like quantum computing. That is at our doorstep, and that is going to be a problem. And the more we explore the conversation about data security, both ends are concerned, the data security, holding that information, and how the government interacts with that information. But if we have it in our hands, we have to make sure that it's safe for our constituents. My question for you is more about the integration of Wyoming stable token. What type of information would a marketplace like TikTok need in order to validate that type of transaction? How are you authenticating that with their users? And are you holding information not only from US citizens, but also international citizens?
Mr. Reisner, go ahead.
Right. So we're buying the American portion of TikTok. So there's 170 million to 200 million, somewhere in there. It ranges users on TikTok. And when we look at the Wyoming stable token, liquidity will be the biggest issue that we face, that you face, Wyoming will face, because they'll have to provide the token that we integrate into the app. So this is already happening. The Wyoming stable token is happening, and it looks like it's advancing quickly from my discussions. And it's data security and what's about to happen is already here. This is today, so it should be a relevant conversation happening. When we integrate it into the app itself, Wyoming will hold the data and be in control of the data through the blockchain. We will integrate the token into the app for all of our users to then make their purchases. So currently, on average, between $500 and $800 a year per American user is being spent, and it equals just a little over $1 trillion a year coming through the app on the American portion. It's $10 to $12 trillion globally. But when we look at TikTok America, we're buying the app. The TikTok shop will be a separate business. So we'll have much further reach with that if we would like at some point to open up to a broader market and increase that. But if we're integrating Wyoming stable token, I think liquidity will be the biggest issue here in handling those transactions. So working very closely with the Stable Token Commission and Anthony Paulo is very important in rolling this out. But Wyoming will have to house the data on the blockchain and have security in place for that. And I believe that we, as owners of TikTok, will require quantum and AI technology to protect the user's data. So the reason we're buying TikTok is for digital sovereignty. And when we talk with federal regulators, this is a big issue. So everything we do will be to protect user data. And if we integrate a third party such as Wyoming stable token, or we use our AI partners, Adelaide, who already protect our most valuable data through HIPAA, we are requiring very, very high levels of security for user data so that it can't be sold or breached in any way. And we're not going to use that in any nefarious way. So I think Wyoming representatives need to strongly look at the development of their data security and whether it's someone's water bill or it is someone making a digital transaction online or whatever it is, really think you should start looking at this early rather than late and try to come up with a solution and at least integrate these in, because we're going to require it on our end if we get the acquisition finished.
Great. Thank you, Mr. Reisner. Any further questions for Mr. Reisner? Anyone on the committee? Oh, I see Mr. Pope's hand up. Mr. Pope.
Thank you, Mr. Chairman, and thank you, Mr. Eisner, for joining us today. This is wonderful that you have been able to set aside the time to come and talk to us. I, for one, am excited about the possibilities that this represents. That I spoke yesterday about it. I think that one of the things the stable token brings to the platform is the beginnings of the types of protected privacy and simultaneously with transparency that we can help with. And for an application, for an app that has and a platform that has been roundly criticized for its collection of data, I think this focus on of yours on security, privacy, and all of that, I think it's wonderful. And I think if we can achieve that and integrate the stable token, that will be wonderful. Other than the privacy or aspects of it, other than the security aspects of it, what do you see as some of the other hurdles if your acquisition takes place? What are some of the other hurdles you see in integrating the stable token?
Sure. So,
Excuse me, Mr. Reisner, go ahead.
Okay. Mr. Chairman. The greatest hurdle that we see right now is integration into the app through Liquidity. To handle $1 trillion currently is a big hurdle. So having enough assets liquid to guarantee it at 102% as is mandated. So the Wyoming stable token is dollar for dollar, $1, one stable token, guaranteed at 102% and backed by United States Treasury. And so ranchers and farmers in our agricultural community already trading commodities through this at 50 or 100 million or 200 million. The liquidity is fairly simple in our budget right now. And to keep it stable is a very simple. So the stable dollar is special, or the stable token is special because it's $1, one token. Even if the dollar fluctuates, the token always remains $1. So to keep it liquid so that I go into the app or any retail application of this, or I tap to pay at the pump using a Wyoming stable token, the money gets transferred to the convenience store. The money gets transferred to the seller from the buyer. So a transaction happens, and then the new holder of the money, the new holder of the token on the other side of the transaction might take that money out. So you have to have liquidity there. So the liquidity need is probably the biggest hurdle right now that the state would face with this integration. So we would have to slowly phase the Wyoming stable token in, or find a way to get it liquid very, very quickly. Because when you're talking about $1 trillion in transactions, how much daily is being used, brought into and out of, so to keep it liquid. Otherwise, you're going to have a massive problem. So do you need a $500 billion sitting there to keep it liquid? You really have to think through these things. That's probably the biggest hurdle right now to overcome, that you're going to have to figure out, and you're going to have to work with some really large financial firms, I think, and really look 10 years down the road even. But hopefully we can integrate this quickly because the opportunity for Wyoming is so massive.
Great. Any follow-up, Mr. Pope?
Yes, thank you, Mr. Chairman. And again, thank you, Mr. Eisner. So for me, this touches on issues that we talked about yesterday with the definition or the reserve requirements and defining those and the periods of time to meet those reserve requirements and the projections on what will be needed. And so I think we continue to explore those issues, and I believe there is an answer out there. The on and off ramps are important, and then again, the other conversation about creating the captive economy and keeping keeping the stable token in circulation as long as possible, so those reserves can be built and satisfied. All of that remains important, and I just appreciate your consideration of it. And I am all for an American Wyoming company succeeding in this purchase. So thank you.
Thank you.
Thank you, Mr. Reisner. Any further questions? Go ahead, Representative Filer.
Yeah, thanks, Mr. Chairman. Mr. Rasner, just pertaining to the bill that we're discussing, do you see the way that it's written right now? Is there anything that gives you reservation or something we might need to add now? Or is this a good template that we can start moving forward and making sure that we keep everybody in the conversation as we move down this road with the stable token and securities and everything else?
Thank you, Representative Filer. Mr. Reisner.
Thank
Any
you,
thoughts
Mr.
on the bill?
Sure. Thank you, Mr. Chairman. So on the bill itself, I think you're going to have to look at blockchain technology and the security on the blockchain, other uses that this is going to. The blockchain is going to be a phenomenal thing for Wyoming in the future. And if we're just focusing on small micro targeted assets being through there, so public information, I think you have to look broader. And then for security, you're going to have to start advancing or at least look at public-private partnerships to advance quantum computing and AI. And I hope it comes from Wyoming. I truly do. And I know I talk to other states, but I truly champion Wyoming every day in this, I promise you. And Wyoming has the capability, we have the energy, and we have the thought leaders that can advance quantum computing, not just for Wyoming, but in America, and be an actual leader on this early on. And it truly is 3 to 5 years out, and you can truly do something amazing. So when you look at blockchain and the Wyoming stable token integration, when you go to the state legislator allocates money to a municipality, that can happen through the stable token in the blockchain. And then Teton County right here spends that money, and it's 100% transparent, those transactions. And I can log in real time and actually see those bills being paid. The problem you'll have is nefarious actors hacking that at a 2 and 4 encryption level. And you really need to look at a higher encryption level through post-quantum computing. Otherwise, they're going to hack your systems and gain access to a lot of information that they shouldn't have access to, but it should be fully transparent. We have sunshine laws, and I truly do agree with that, but the security levels have to be there if you're looking at data security. Or when I go to pay my water bill, it could be through the Wyoming stable token. And if you actually want to make it actually something huge, you can actually start offering retailers and small businesses the opportunity to use the stable token, which then begins to compete with Amex or Visa, because instead of a retailer getting charged those 3 and 5% charges per transaction, it is a small 1, 2, or 3 cent charge through the blockchain. So the opportunity for Wyoming starts at $30 to $50 billion per year, just collecting the interest off of the treasury bills. But truly, it's much, much greater than that if you think larger than just TikTok and the applications that present itself, because we can actually use this in Wyoming, and other states can license it. And we just have to be able to have liquidity. And I think Director Apollo and I will discuss this, because I have some really great partnerships coming up that will make it very liquid for all of you that I can present at a later date. But I think the opportunity is abundant, and I think Wyoming is leading and should stay ahead of the curve.
Excellent. Thank you, Mr. Reisner. Appreciate it. Appreciate your testimony and joining us here today in Jackson. Sorry about the weather.
Oh, it's beautiful up here. We're good.
And we look forward to working with you again in the future, and good luck with the acquisition endeavor. We hope to see that conclude soon.
30 days. We're getting there.
30 days. Sounds good. All right. Appreciate it. Take care. All right. With that, I don't think we have any more public testimony. Public testimony is closed. Back to the committee on the bill draft, and Mr. Co-Chairman, discussion for the committee on how we want to proceed. I think this is probably one we could technically pass it today, but honestly, it's probably a good bill to have more public comment on and leave open for further discussion if everyone is comfortable with that. So I just leave it to the committee to have any thoughts on things that we should do as this moves forward, or what action we should take. Any thoughts on data privacy government entities committee? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. I would agree with you. I think that it's very clear that we have public support on our endeavor, but we also are being asked to take it a little bit slower. And so I think some more time to reflect on this and talk to some more stakeholders. I think that would be appropriate. And so your idea seems like a wise one.
All right. Anyone have any concerns with that approach? So we'll move it forward to either the next or the following legislative meeting. We'll basically play that by ear a little bit. Okay, seeing no concerns with that, let's move on to special purpose depository institutions, and updates from our speedies is how we'll start. I don't think we have anyone in the room right now for speedy updates, so we're going to be hearing a little bit from Zoom. And do we have Miss Fellows online? Okay, let's bring.
We do, Mr. Chairman.
Let's bring Miss Fellows in with Bankwise. I see Miss Long.
Good morning.
There's
Can you
Ms.
hear me?
Fellows. All right. Yes, we can. Welcome, Ms. Fellows. Please introduce yourself to the committee, and we look forward to your update on Bankwise.
Thank you. Mr. Chairman, Mr. Co-Chairman, members of the committee, thank you for the opportunity to speak with you this morning. My name is Julie Fellows. I'm the co-founder and CEO of Bankwise, a special purpose depository institution. I'm happy to be here today because it's such an exciting time with so much happening in the digital asset space. Deals are closing every week, and legislators and regulators in Washington, D.C. are opening doors for banks to actively participate in the digital asset ecosystem. Bankwise has experienced the benefits of this excitement, signing new strategic alliances, increasing our LOIs, and actively engaging with numerous entities interested in our capabilities. However, not all the activity, particularly at the federal level, is beneficial. The OCC and FDIC have relaxed rules and are now allowing federally chartered banks, in essence, the ability to directly compete with speedies. Yet these modifications are not backed up with the proper legislation and regulatory infrastructure that Wyoming has created over the last decade. In my opinion, the Wyoming regulatory framework and oversight is the biggest competitive advantage speedies have, but few people really understand this. I have 3 requests from the committee today. The first is that we get support from the state in educating the industry regarding the innovative regulations that have been adopted in Wyoming over the last decade. The laws, the regulatory infrastructure, and the charter capabilities and services that the state has vested in speedies. The second is continuing engagement with other states to obtain reciprocity. And third is for engagement at the federal level. We appreciate the efforts that are already ongoing. We heard from Mr. Land yesterday from Wyoming in connection with pending federal legislation, such as the market structure bill and the stablecoin legislation. Ensuring that speedies are included in some of the currently contemplated considerations regarding qualified custodians is absolutely essential. A failure to do so could effectively undermine the regulatory framework that Wyoming has adopted. In our view, it's important for Wyoming representatives to protect the regulatory regime it has passed by engaging at the federal level whenever possible. If speedies are not included in some of the currently contemplated legislation, this will effectively undermine the regulatory framework that Wyoming has adopted. In conclusion, Bankwise believes that this committee should continue to be the leaders in digital asset space as the market evolves. Wyoming has always been at the forefront of creating a regulatory framework for digital assets. Adding new services and capabilities to the Speedy Charter in a regulatory compliant way will enable Wyoming and the Speedies to remain one step ahead of the competition. Thank you, and I will stand for questions.
Thank you, Ms. Fellows. Any questions for Ms. Fellows? Ms. Fellows, we did hear from Mr. Land, and it does seem like, assuming that the language that is currently in place is adopted, that the Genius Act and I believe also the Stable Act have appropriate language to address issues concerning reciprocity and recognition of speedies in all states. Is that your understanding as well, that we're in a good place, at least with the language that we have in that to address your second priority?
I believe, Mr. Chair, I believe that is true. I know that there's negotiations ongoing, and so exactly what that language is, I am not certain. So yes to that piece as far as I understand.
Excellent. And I certainly appreciate your concerns that we are seeing, it's the old, when the pendulum swings, it always swings a little too far, right? We were being over-regulated at the federal level, clearly. And now perhaps we're going to under-regulation, where the desire to have the robust regulation that we have in place for the speedies is largely being thrown out at the federal level by the OCC. And so we'll have entities that don't have any credible regulation, custodying digital assets, and we'll end up with the problems that we actually sought to solve through the speedy potentially in the future. So we've got to fight that too. Further questions for Bankwise? Nope, seeing none. Thank you so much for the update. We appreciate your work and appreciate having you here today, as always.
Thank you.
All right, and I see Ms. Long on the screen, our longtime veteran of the Select Committee and Task Force before. It's great to see your face, and we look forward to hearing an update from you and Custodia. And we did get your written materials as well, so thank you for providing that ahead of time.
Thank you, Co-Chairman and members of the Select Committee. Caitlin Long, coming to you from Cheyenne, co-founder of Custodia Bank. Thank you for inviting me to update you this morning. Custodia recently made two big announcements. In March, we launched the first ever tokenized bank deposit issued on a permissionless blockchain called Avits, working with San Antonio-based Vantage Bank. Avits use the same technology as stablecoins, but they're issued inside the traditional banking system rather than outside of it. Users gain many benefits and consumer protections by accessing stablecoin technology from inside the banking system. Avits bring to the banking system the enormous network effects already built by permissionless blockchain networks such as Bitcoin and Ethereum, as well as tap into their inherent interoperability by using open source permissionless backend technology. Then, 2 weeks ago, Custodia and Vantage followed up by announcing the first cross-border use of Avits by a Mexico-based logistics company, DX Express, whose trucks ship goods between Mexico, the US, and Canada. DX Express's CEO perfectly captured the utility of Avits. He wants the company to be able to programmatically pay its truck drivers within an hour of reaching their destination, which will help it recruit the best drivers. It's literally not possible to do that cross-border today due to the limitations of incumbent payment systems. Vantage has received substantial incoming interest from traditional businesses that want the choice to pay some of their suppliers this way, as well as from traditional banks and fintechs that want to offer this choice to their customers too. Of course, not every business wants to pay every supplier quickly for every payment, but some do in certain circumstances for competitive reasons. Custodia and Vantage are proceeding with our plans to bring this new US dollar payment alternative to business banking broadly. Both of us have been working closely with our bank regulators regarding these transactions and will continue to do so. Next, here's an update on debanking, a term that went mainstream in November 2024 when A16Z founder Marc Andreessen revealed on Joe Rogan's podcast that most crypto companies in Andreessen's portfolio had been debanked under federal regulatory pressure to kill the crypto industry, which became known as Operation Choke Point 2.0. Of course, this select committee had been discussing debanking for years before the term went mainstream. By the way, just today, the New York Times decided to cover it. But indeed, in 2019, several legislators voted for the Speedy Bill to help fix the debanking problem that had hit other Wyoming industries. So how's it going? Well, debanking is still a problem, and the Fed is still preventing Wyoming from solving it ourselves. by blocking payment system access for all Wyoming Speedy Banks. But the Fed didn't just block Speedy Bank's payment system access. It told the courts Speedy Banks could obtain such access via partner banks instead, while simultaneously pressuring the partner banks to shut off our access. It's clear what the Fed was up to. Custodia was repeatedly debanked in 2023 and 24 due to no fault of our own and despite our clean compliance and operating record. So after Custodia endured yet another one of the repeated debankings, each set us back months and cost us millions, late last fall, we hunkered down to await the policy turn. Custodia remains in the banking business and remains in good standing with our regulator, but we downsized and returned customer funds in several of our business lines. In total, we returned $74.4 million of customer funds with no customers losing money or filing complaints, without incurring a bank run, and while maintaining a clean compliance and operating record. Our deposits were so sticky that Custodia literally had to chase some of our depositors to take their money back. In other words, we had the opposite of a bank run. So our 100% reserve business model, our 100% reserve business model had a real world stress test and performed beautifully, as did Custodia's team. This is a really important fact. It's no wonder Congress modeled the stablecoin bill's proposed new payments bank charter on Wyoming's Speedy Charter. So speaking of the federal stablecoin bill, which President Trump has asked Congress to announce by August, its status is changing day by day, although I just found out they're going to try another cloture vote at 12:15 Mountain today. Custodia does support it because it helps Wyoming Speedies in certain respects, but Vantage and Custodia have been able to proceed without it. Moving to the federal bank regulators, all three of them, the OCC, Fed, and FDIC, recently rescinded their Biden-era anti-crypto policies, except that the Fed actually left one in place. When the Fed announced it had rescinded 4 of its anti-crypto policies, but omitted any reference to leaving itself a backdoor by keeping its 5th and most punitive one in place, Senator Lummis denounced the Fed's disingenuousness. The event also triggered something rare. The lobbying groups for the banking and crypto industries actually agreed on something, calling on the Fed to rescind its last anti-crypto regulation. So far, the Fed has ignored such calls, and it has also not yet acted on the White House's executive orders on the topic. But Senator Lummis did achieve an important concession from the Fed in February after she exposed the existence of a different Fed policy that matters to this committee, and the Fed had kept it secret. Behind closed doors, the Fed gave itself the power to itself debank any bank by blocking access to the payment system if the bank engaged in quote unquote controversial commentary or activities. Whatever controversial means, the facts show that the Fed put crypto into the controversial bucket. Shortly after Senator Lummis publicly confronted Fed Chairman Jay Powell about this, showing him, quote, hard proof of Operation Choke Point, which has now been discovered by Congress, Powell announced he rescinded the provision. But the whole thing is still cloaked in secrecy, so only Fed insiders really know its status. The episode tells us a few things. A, that such a secret debanking policy did exist at the Fed. B, that the Fed only rescinded it after being publicly called out by the revelation that the Fed had secretly made itself judge, jury, and executioner of any bank it doesn't like, with zero due process and no prior notice by the Fed that it even had such a policy in place. And C, unfortunately, we also now know that the Fed's secret policy did acute damage to all Wyoming Speedy Banks. Related, on stage a few weeks ago at the DC Blockchain Summit, Governor Gordon revealed what then Vice Chair Lael Brainerd had told him when discussing Wyoming being the leader in crypto banking before large states like New York followed suit. He said she told him, well, we really love what Wyoming is doing, but we've got to wait until somebody bigger comes along. That is an outrageous admission of bias. I would actually say contempt against a small U.S. state by the #2 Fed official. Thankfully, though, things might be changing. President Trump nominated the former Kansas Bank Commissioner to be the new Fed Vice Chair for Supervision. She has already brought in new staff who previously praised Wyoming for what we have accomplished as a state in crypto. Will these new Fed officials be allowed to effect change at the Fed? We'll see. Net, unfortunately, the Fed caused Wyoming to lose most of the state's substantial lead in this area. But depending on how things play out this summer, Wyoming could still retain at least some of that lead. A few proverbial green shoots are coming up in DC, plus oral argument in Custodia's lawsuit appeal was January 21st, and a decision is pending in the 10th Circuit. So stay tuned. I'll close by again thanking you, the Wyoming legislature, as well as the Wyoming Division of Banking and Custodia's stakeholders. Custodia survived the anti-crypto onslaught from DC, of course, deeply wounded, but alive to reach the other side. And we're continuing with our lean but agile team to advance our vision. Tokenized bank deposits were part of Custodia's business plan when our bank was chartered all the way back in 2020. Finally, they're coming to fruition, and that's truly exciting. Thank you.
Thank you, Ms. Long. Appreciate the testimony. Any questions for Ms. Long? Any questions? I have one, and that is, with the new insights related to the Fed's behavior, that information being discovered after the oral arguments and the Custodia appeal, is there any way to bring that information into the appeal? I don't know how that would work since the oral arguments are concluded, but it seems like it's relevant and important information. So any thoughts on that?
Thank you, Mr. Chairman. Most of the evidence in the Custodia lawsuit is sealed, and I can't comment on whether that document was included in the sealed documents or not.
Okay.
I'll leave it at that.
Okay, thank you. Any further questions? All right, seeing none, thank you once again for the update, and we're very hopeful for the decision going Wyoming's way and your way.
Thank you. Thank you all.
All right, I see Trevor on the screen from Kraken. Welcome. Please introduce yourself to the committee, and we look forward to your update regarding Kraken, Speedy.
Thank you, Mr. Chairman, Mr. Co-Chairman, and members of the committee. I am Trevor Rutar, CEO of Kraken Financial. I'm also joined by our CFO, Brian Mathena, if there are any questions for him. Of course, we thank the committee, for the opportunity to speak with you today and provide updates on Kraken Financial. Since we last spoke, we've actually seen a significant expansion in our product offerings. We now support a broader range of digital assets. We've grown our client base, which includes institutional clients and high net worth clients that are looking for secure and regulated custody solutions on a full platform. We've rolled out different features such as request for quote trading functionality and prime services. We've enhanced our application programming interface, or API connectivity, which improves access, execution, and integration for our clients. We've recently completed our proof of reserves audit, our financial statement audit, our SOC 2 Type 2 certification audit, and BSA, AML, KYC independent audits. These audits reflect our commitment to transparency, financial integrity, and strong compliance practices. I'll give a little teaser to the committee. We are working with Senator Lummis on an announcement in the near future, which underscores our long-term commitment to the state that I think this committee will find particularly exciting. We certainly thank the committee for its work in passing the SBDI amendments bill last session. These amendments reduce friction and make Wyoming an even more exciting place to do business. Everything that we're building reflects our alignment with Wyoming's goals, supporting responsible innovation, establishing Wyoming as a hub for digital asset leadership, and operating in a safe, sound, and secure manner. So that's a short update, a little bit operational, but I'd be happy to answer any questions that the committee may have.
Thank you, Mr. Rutar. Any questions for Trevor and Kraken? Questions at this time? All right, seeing none, Trevor, thank you so much. And, we're excited to hear that announcement, to look forward to that, as well as always appreciative of the investment Kraken's made in Wyoming to locate your services here, and hearing about the growth of those financial services in Wyoming is excellent. So, we'll look forward to additional interactions and feedback, as well as we've got a discussion coming up. This is for all of our Speedy Banks. whether there need to be any tweak amendments or anything along those lines in the next bill draft. So if you have any ideas, we'll be looking at those in the next couple of minutes. So stick around. But hopefully we covered most of what we needed in the last legislation. So thanks again. Appreciate it.
Thank you, Mr. Chairman. We'll hang around.
Excellent. All right. Do we have Commercium online? Excellent. Let's bring them in. All right, I see you. Welcome. Please introduce yourself to the committee, and we look forward to hearing your comments.
Thank you, Mr. Chair, Co-Chair, and members of the Select Committee. I'm Rob Slater, Director of Commercium Financial. I want to thank you for the opportunity to provide updates today, and additional thanks to our fellow SPDIs for their continued commitment to ensuring Wyoming remains a state and national pioneer in digital finance. So congrats, Caitlin and Trevor, on some of your most recent successes. Today, I'd like to ask the collective team that we definitively recommit to that vision to maintain our position of national leadership in this emerging and competitive landscape. In Jackson last year, we envisioned a unified front between the state and SPDIs to drive economic growth through national leadership in emerging tech. While initial discussions were promising, overall progress stalled after only a few meetings. And without regular channels for communication in this very dynamic environment, we've struggled to address some stakeholder concerns about regulatory timelines, the overall impacts, and providing alternate approaches to building the overall SPDI. We've witnessed a little bit, even leading some of the interested parties to explore other states like Texas, New York, and South Dakota. We've all seen the positive momentum shift in national sentiment towards digital assets. However, it has led SPDI potential investors and customers who are initially excited by Wyoming's framework to hesitate when faced with known uncertainties, specifically uncertain relationships with the Federal Reserve and the overly intensive capital requirements. These challenges, compounded by the FDIC's new guidance that supervised institutions may engage in permissible crypto-related activities without receiving prior approvals, is making it harder to champion the story of why Wyoming. However, our recent re-engagement with the Kansas City Federal Reserve and Wyoming Division of Banking has been very promising for us, highlighting the shift to the acceptance of the new technology that everyone here has known was inevitable. We feel the tone of discussion with the Kansas City Federal Reserve has turned to a more collaborative conversation, which is maybe a little bit different than it has been in the past. We believe these type of collaborations are essential and will require a very intentional and direct approach by both SPDIs and the state of Wyoming. First, I would propose the creation of a formal SPDI advisory council, meeting maybe quarterly, to connect industry insights and demand signals to appropriately coordinate with policy decisions. Second, we would publish a clear, transparent, and public roadmap for SPDIs, including federal integration, to reduce uncertainty through clarity. I believe this commitment will have a huge impact on the already strong digital asset foundation established by Wyoming and will inevitably drive massive economic development for the state if the visionaries have the freedom to operate in making Wyoming the primary home of this inevitable trillion-dollar market. Commercium is eager to participate and partner in this renewed effort. Wyoming's SPDI framework is a bold legacy, and we must protect its brand and expand its future to keep Wyoming the gold standard in digital finance. Thank you for your time, and I welcome any questions.
Excellent. Thank you, Mr. Slater. Appreciate that. Any questions, committee? Questions for Mr. Slater? Mr. Slater, we hadn't discussed before the idea of a speedy advisory council. I think that's a novel and potentially valuable idea. Is that something that you've discussed with our other speedies? Is that, and we've got a few of them obviously here with us. Would that be something that we could get up and running, and maybe have it coordinated through the speedies, but legislators could certainly attend that, and other policymakers? How would you envision that?
Thank you, Mr. Chair. So the SPDIs, we've all talked about it, what it might be, what it might not be. Should we do it? Should we not do it? I think when we left off was, late in 2024, and it was still like we wanted to see, how are things going to shape up before we, formally commit to something like this. But we need to re-engage on our side to see what that might look like. I can speak only for myself. I'm all in and ready to get after it, but happy to take in inputs and figure out what this might look like and what the benefit is for everyone involved and how to kick it off.
Great. No, I'd appreciate that. And yeah, I'll look to you to kind of lead that charge and get the input from the other speedies to see if we can put that together. And I'm happy to support that if it does end up coming together as you suggest. So thank you for that. Thank you for that possibility. Subcommittee, any other questions? All right, seeing none, thank you for the update. We really appreciate it. We appreciate you joining us and providing that testimony. All right, I think that's all we have as far as updates from speedies at this time. Great, and we, all positive updates. That's excellent. So let's move on now to, yep, go ahead. Oh, okay, let's see. Mr. Kaufman, I know, well, let's see if you have an update. Mr. Kaufman, do you have any further update with regard to speedy updates?
No, Mr. Chairman, I was just coming online as we start talking about the legislation. There was a few other things I just wanted to mention for the committee's consideration, but I can wait till we talk about the bill drafts.
Perfect. No, let's go into that because our next point of discussion is going to be speedy amendments discussion, kind of the general what would we need to tweak, and then we do have a few bill drafts to contemplate that are specific issues that have been identified for updating. So if you have any general speedy amendments that we should potentially begin a bill draft of or begin discussion of, this is a great time to bring those up.
Yeah, thank you, Mr. Chairman. I do have one that I think is at least worthy of the committee's consideration. As we've worked with several of the speedies and just hearing the testimony from all of them about some of the challenges nationally, particularly when it comes to the competitiveness. One of the things that keeps coming up, and I know hopefully Commissioner Bishop is there. This is not a surprise to him. We've talked about this a few times over the past few years, but under the current statutory framework in 13-12-106, if anybody wants to look it up, there's a requirement that the speedies develop a contingency account. And in practice, this has been more cumbersome than I think a lot of people anticipated. We already have a number of safeguards in place for the speedies, including the 100% deposit guarantee, the initial capital and the surplus capital that's required upon formation. The commissioner has pretty broad rules and authority with respect to ensuring liquidity and mitigation of risks, et cetera. But this is one that just keeps coming up that I think some of the speedies and certainly some of the applicants, as we've spoken to applicants, just frankly find cumbersome and are concerned that this is creating some competitive disadvantage for Wyoming. And so I just want to call that out specifically for the committee to look at. I think it would be a relatively simple legislative lift, but obviously, want to give everyone an opportunity to look at that, consider it, and obviously get the commissioner's input as well.
Excellent. I appreciate that. Any questions for Mr. Kaufman on that? So we're talking 13-12-106. I was just pulling it up as we were talking. And as I recall, this was one of we put in multiple layers of additional contingency and assurance to replace the fact that there wouldn't be a requirement for FDIC insurance. And this is one of those. So is it, I guess we can bring up Mr. Bishop in a second and kind of talk through what the differences would be if we played this out. But the 102% would or would not still be in place at that point, because that is part of 13-12-106. Which aspects, Mr. Kaufman, are you looking at eliminating?
Yeah, I think that's ultimately what we're getting at, Mr. Chairman, is that deposit funded contingency account.
Okay. So the bonus 2%, I see. Okay. All right. Committee, any questions on that? Any further amendments that are just general amendments in addition to the bill drafts, Mr. Kaufman, that you see that we would
Not-
need to the act?
Yeah, not at this time, Mr. Chairman. I know we have some bills that we're still going to discuss. One of them being the conversion aspect that we talked about last session. I certainly have no objection there. Yeah, we just ran out of time last year, but
great.
Yeah, no further comments.
Exactly. All right. Does anyone else have anything to bring up for speedy amendments discussion, whether it's select committee, or we can bring up Mr. Bishop and see if he has any more tweaks while we're on that topic before we get to the bill drafts themselves. So, Mr. Bishop, welcome. And obviously, please identify yourself for the select committee, but maybe a little thought on Mr. Kaufman's suggestion of revisiting that contingency account, as well as any other amendments that are outside of what we're going to be looking at through the bills.
Yes, thank you, Mr. Chairman, members of the committee. Jeremiah Bishop, State Banking Commissioner. Yeah, this is as far as the contingency account that Mr. Kaufman was speaking to. This is something we've been talking about for quite some time with him, and then also all four of the existing SPDIs. My understanding was kind of what you summarized was when this was first put into place, this was just one extra layer on top of multiple other layers of kind of make everybody feel good that this is a safe institution. I think to make it very clear, I think we'd be support the recommendation just to repeal all of 13-12-106, both A and B entirely. Right now, this only comes into play once a speedy's been operating for 3 years. So far, nobody is currently having to have this 2% account. However, we've been in discussions with some of the ones that are getting close, and I think the strength that it gives is not quite enough. It doesn't outweigh the burden of complying with this. The way this works is once a speedy's been operating for 3 years, you must have at all times a contingency account of 2% of total deposits. That can either be funded through capital, in which case your shareholders are putting up that 2%, or your actual deposit customers are having to fund their own 2% contingency account. So for every $100 put in, they must put in an extra $2 for their contingency account. And so you're going to have to develop some system to make sure that that is always in compliance. You must have a pretty strong customer agreement, making sure they know what this is, because it is not a deposit liability. It's a different type of liability. And it's kind of awkward, honestly. And I don't know if it helps as much as I think it should. There's already the 100% liquid assets for the deposits. And then there's also capital requirements in general. They must comply with all bank capital requirements. So I think there's enough layers here to make sure that customers are protected. So I don't think, again, more of a discussion item, if there is any extra benefit that this might have. We've discussed this with Mr. Kaufman, and like I said, in the other speedies, I think we can all be in agreement that I don't know if it's worth keeping. So I think we'd be in support of just repealing all of 13-12-106, both A and B. So,
all right. That's
and with that, I didn't have any other items or that could be or amendments. So,
well, let's see if there's any questions or discussion on that. Anyone have any questions for Mr. Bishop on 13-12-106? Okay. Seeing none, thanks for that. And no, so we're good otherwise as far as amendments. That's great. All right, if we want to do that, that's a clean and easy bill. It's a one-pager with a repeal, so we can contemplate that and discuss, committee. With that, let's move on to our two bills, and you can stay up here and we'll have Talise come and walk us through these bills pretty quickly, but we'll want your input on them. So let's move to 26 LSO 13, special purpose depository institution conversion.
Mr. Chairman, members of the committee, Talise Hanson, Staff Attorney Elso. I'll start with 26 LSO 13, version 0.4, special purpose depository institution conversion. So just a high level overview of this one. This bill draft authorizes the state banking commissioner with approval of the state banking board to convert the charter of a special purpose depository institution to a state bank. It requires a speedy to file an application to convert, which contains a comprehensive plan. The bill draft outlines further requirements for the application and the comprehensive plan and a process for reviewing the application, including criteria that must be considered. It specifies that if the application is approved and a charter is granted by the board or the commissioner, then the converting speedy shall not commence business as a state bank before receiving a certificate of authority to operate as a state bank from the state banking commissioner. The draft outlines the requirements for an application for a certificate of authority and the process for approving or denying a certificate of authority. And it specifies that a state bank that results from a conversion is deemed to have been in existence for the same period of time as a speedy and shall surrender its certificate of authority and shall not use the term special purpose depository institution. And then the other bill, 26 LSO 14, does the opposite. It allows the state bank to convert to a special purpose depository institution. It has all of the same requirements and very similar language, just wherever state bank is used, it's flipped.
You reversed it, yeah.
So other than that, if you want me to go into more detail, but it's just the same language, just flipped around.
No, I think that sounds good. We kind of know what it does. Any questions on the language of the bill before we go to Mr. Bishop? Questions on the language? All right. Thank you, Talise. Appreciate that. And so as a bit of background, right, this topic came up ahead of last session. We had legislation that looked at conversion to a trust. There was interest in conversion, possibility just having completeness in statute that would allow a speedy bank to become a state bank. And then there was discussion of state bank going to speedy. There was too much that needed to go into it, so that language wasn't available as we were working through the trust conversion, and we're bringing it now for completeness. We have similar language throughout Title 13 that allows various types of conversion, and so we're trying to make sure that we have a fully complete product for the speedies that allow conversion into a speedy, outside a speedy, and how that would happen without having to terminate the speedy and create a new bank or vice versa. So this is to a large degree statutory cleanup, trying to ensure that we have all of the processes anticipated that industry could want, the financial sector could want with regard to conversion into and out of speedies. So with that, Mr. Bishop, can you feel free to provide us with any insights or concerns that you might have with these bills? And I know that you've been working with us on them, but the floor is yours.
Yes, thank you, Mr. Chairman. Again, Jeremiah Bishop. I'll talk first on, I think it's number 13, the SPDI conversion to a state bank. I know I had some items that needed to be added during the session. I believe they have been. The main concern I had, I think, is on page 4, lines 15. Some of our bankers reached out to make sure that 13-12-209 was added, and I see that it was. So I think that concern is covered. Just making sure that it's the hearing process is what that concern was. If this goes forward to the state banking board, traditionally that is an actual formal hearing that is held. So I think that concern was made or was addressed. The other questions I had during the general or the session were more, I guess, theoretical questions that I thought deserved more discussion. The first one was lending. My understanding of when the SPDI was first introduced, there was a large part of the way it's drafted, the way it was, is that if you're dealing with digital assets and virtual currencies like a speedy does, it is not a good idea to mix that activity with bank lending. That's why SPDIs are prohibited from lending activity. This bill would allow them to convert to a state bank, still conduct that activity, but then take on the lending function. That is one of the largest differences between a traditional bank and an SBDI, is that lending prohibition. So I think I just wanted to make sure that there was some good discussion on that. Maybe things have changed, and that is now something we can all be comfortable with. But I did want to just kind of tee that up for further discussion, just to understand, okay, if things have changed, what did change, and are we okay with this risk? I'm not saying I'm not okay with it. It's just, yeah, I'd like some more discussion on this.
Well, the question I would have for you is, how would that proceed? It seems like that risk analysis would be done as part of the conversion, and the commission would have to become comfortable that we'll call it the product risk, right? Whatever the product institution is out of the conversion would have to satisfy risk concerns and have those risks appropriately mitigated, whether that was through FDIC insurance, which I believe would at that point be required based on our statute. No, I guess it wouldn't necessarily be required. You might require it, but I don't think it's statutorily a requirement. But whatever is put together at the end of it, the commission would have to feel was a financial institution that the commission's comfortable with from a risk standpoint. Is that accurate?
Yes, Mr. Chairman. Yes, I think that is accurate. I mean, right now, a traditional bank can't offer digital asset custody. Currently, now they would need their approval from their federal agencies. So again, I'm not opposed to this. It's just that was one of the core foundations of it, the SBDI, is they shouldn't be lending. I think there's ways around that to make sure that that risk is appropriately managed, and that is something that we would look at on this conversion, making sure they have all the policies, procedures, and staffing in place, among many other things. This would be a very big lift, but we could work with it. I did want to address one thing that you mentioned, just it was on my list of another discussion, was just that the aspect of FDIC insurance. The way that this process, I think, would work is with insurance is the certificate of authority to commence business. This is a 1312-213. This is one of the things they would have to submit to us before they could officially become a traditional bank. And one of the lines in this is let me find this. They will attach evidence that the appropriate federal insurance of deposits has been obtained. That's currently in law for traditional banks, and this would apply to an SBI converting. So yeah, I think it is implied that it doesn't specifically say FDIC. Sure. That's the only federal insurance they'd get. So they would have to get FDIC insurance before they could actually open their doors as a traditional bank. That was one of my other discussion topics, is that something that we want to have in statute as being necessary?
Well, it would be, right? I mean, based on what you just said, as it currently stands, it would be. They would end up having to have it because that becomes applicable to them. There is only one federal insurance. So I just interpreted what you said as drafted, they would be required to have FDIC insurance at that point. So as we were working through this in the past, obviously, and when we created the Speedy, the FDIC insurance was one of the things that we were trying to work through. At the same time, the feds, there was no chance of a national bank having access to digital assets at that point in time, zero. So we were trying to create a circumstance where we could have access to custodying digital assets. At this point, moving forward now, and we just had testimony about the fact that we have this awkwardness at the national bank level where national banks are being granted access to digital assets within their current business model. And, it's a bit of a regulatory nightmare. They don't have the wherewithal to appropriately regulate those digital assets in a lending environment. So one of the concepts here is Wyoming shouldn't put its state chartered banks in a position where they fall behind what you can do at the federal level. So we need to achieve, even if it takes regulatory work, even if it takes the commission having to think through how to de-risk the entity, with the two-tier banking system, our state chartered banks should be in a competitive position with federal banks. And so I guess the question is, does this bill conversion approach give us that opportunity. So if nationally chartered banks start custodying digital assets and our state banks want to do that, we need to be in a position to do that. And if it's coming from a speedy bank, this would be the way to get there. Do you feel like there's anything we would need to change either with the FDIC insurance or with the language that would ensure that we have that opportunity available for our banks?
Yes, thank you, Mr. Chairman. As far as being competitive with national banks, assuming an OCC national bank, that a traditional bank with lending activity decides they want to do digital asset custody or other, digital asset related activities, there's a lot of other ones they could do. This would allow our speedies to, I think, be on a fair playing field with those banks, because right now the SPDI does have some significant guardrails in place. They cannot lend. That's significant. That's most banks' earnings is lending. Speedy banks, that's one of their biggest hurdles, is making money when you can't lend. However, there's risk to that that banks can deal with. So I think as a bank regulator, we're very familiar with that. We can help in SPDI making sure they have a lending function in place. I guess one of the questions I had with this is, if we want a fair playing field, why should we even have an SPDI? The benefit is the 100% backing of deposits. That's the real strength of the SPDI. But if to be on a fair playing field with national banks, you must be a traditional bank with lending and insurance. You can still back all your deposits 100% if you choose to. You won't be able to because you're probably lending, and you kind of have to lend. Actually, there's CRA requirements that you'd have to now comply with. But if this is what we're trying to do, is actually have a true fair playing field, why have the SPDI at all? What benefit does it have? I know some of the answers to this. I'm not saying that's not the case, but more of a discussion.
Well, I think the first answer to it in my mind is you certainly wouldn't get rid of it. But if you open up a new option because that option is becoming available at the federal level, then you really see how the market evolves. And if we get to the point where we have zero SPDIs because everybody has converted into a traditional bank and they're still custodying digital assets, that's just the nature of how things went. And at that point, the argument for you wouldn't need a SPDI is true. But at the same time, we're not there yet. And I think that risk of FDIC engagement, of having to have that federal vector is going to potentially continue to be a problem. We might not be done with that. So just making sure that we're advantaging our financial institutions to the greatest degree possible while not providing undue risk seems like a reasonable objective for this select committee as we're looking at financial technology.
Definitely, thank you for that, Mr. Chairman. And I agree. I think with this bill, I wouldn't say those were concerns I had. Again, they did deserve a discussion.
Sure.
The other one I did want to bring up, and again, this might be something we can think of and collectively and bring at the next meeting, is capital requirements.
Okay.
If an SPDI were to convert to a traditional bank, they would have to obviously comply with traditional bank capital requirements, which they already are currently doing. But one of the things with the process that's in this bill is they have to go through the actual charter application process. Is the same process as if a de novo bank was getting chartered. And that was done for a reason, because they're significantly changing their business plan. So I think they should have to comply with the same factors. But one of those is capital requirements. For a traditional bank, the de novo process, the initial capital is the 5 million capital stock, 20% surplus, and 1 year operating expenses. And now that's for kind of assuming that it's an actual true de novo entity. For an SPDI, they have likely been in operation for years by this point. They may be in compliance with ongoing capital requirements, but it depending on what that 1 year operating expenses is, that might be a significant increase. Maybe it's a decrease. I don't know. That's kind of my point, is if it's a significant increase, do we want them to be capitalized like a true de novo bank? Or as long as they're in compliance with normal capital requirements, is that sufficient?
That's a good point. I don't know what the rest of the committee thinks, but I do think that adding a bit of language tweaking that just a little bit to say that they're capital compliant through they've maintained capital compliance, whatever the right language is, as opposed to having to achieve de novo. Haven't we been using, I felt like we were using 10 million as the initial capital compliance for Speedy Bank instead of 5 million. Am I misremembering?
Yes, Mr. Chairman. So the statutory minimum is 5 million capital stock, 20% surplus, and then operating expenses. So our minimum is 15 million. That's kind of what we've set as our capital pledge to the division. So that's kind of our minimum. But then that 3 years expenses generally greatly is higher than that. So that's what that was.
Okay, so that's what I'm thinking. All right, that makes sense.
And so what I would say, we can work before the next meeting, maybe work with LSO on some language in there. And maybe leave it more open, I'd say, because depending on the business model of you must have the minimum capital requirements for traditional banking regulations or any other capital as determined by the commissioner for that specific business model.
That sounds good.
Just to leave, we don't want to back anyone into a corner is kind of what I'm getting at.
Definitely. Yep, that sounds good. Anything else? I mean, that's a good consideration. We could certainly take that into account.
Not on that bill. I'd like to talk a little bit on the other bill, the traditional bank converting to an SPDI.
Sure.
I guess my main question is just why? If you're a traditional bank, you've already gone through the charter, you already have federal regulation, you already have insurance. You either have a master account or a correspondent account that's already in place. I've been talking to some of our traditional banks. Why would you want to give that up for the very high guardrails around an SPDI? Like I said, the SPDI has some significant guardrails in place. Their capital is much higher than a traditional bank. A traditional bank for de novo is 1 year expenses. For SPDI, it's 3 years expenses. That's one of the issues. Also, just if you want to do digital asset custody, you can as a traditional bank. Now you can, again, you have to work with your federal regulator, but you're giving up a lot to convert. So I guess my question is anyone asking for this?
No.
Or is it just kind of a cleanup bill?
It's a cleanup bill.
So I understand. Yeah. So that's one thing. But what some of the other specific things was actually, again, similar question, capital requirements. Again, if you're a traditional bank that's been operating for years, you just have your minimum capital ratios you must comply with. If you want to convert to an SPDI under this language, you're treated like a de novo. So you're going to have to likely increase your capital significantly, which I think is fair. That's what SPDIs have to comply with.
Right.
So I think that's fair. But I guess similar questions just in reverse. Again, if I'm not opposed to this. If somebody wants to do this, this provides an avenue and it's already in place. We don't have to bring it forward out of future legislation. I just don't see the use case for it.
Candidly, I don't know that anybody has suggested a use case. When we talked about it, it wasn't because there's anybody out there saying, boy, I sure wish we could switch to a Speedy Bank. It was more the completeness, which is so you can switch in one direction, but you can't switch in the other. Why? If we're going to do one, why wouldn't we just go ahead and clean it up so that both conversions are legally allowed? And we don't do a very good job of predicting use cases in the future of where industry goes. So the fact that we can't see one right now doesn't mean that we wouldn't in the future.
Okay, no, I think with that, again, that was my main question. I think everything else that goes in reverse, again, you have to follow the same process as de novo SPDI. I think that's fair. You still have to go to the banking board or myself if the banking board determines it. I think that's fair. Now, what we would do is significant rulemaking on this one because now you're prohibited from lending. You have to wind that down. That's not an overnight project. So that's part of that application process. Is we're not even going to accept it till you have a significant, a robust conversion plan. That's something we can do, and we'd go the other way with the other bill. You now have to develop the lending platform and CRA compliance, things like that. But it's not something that is overly burdensome. It just, I think rulemaking could address all those items.
So that is a good question. I think the plausibility of a use case on the Speedy to state chartered traditional bank could happen, right? I mean, I think getting that in place is important. The only downside that I've heard so far to having the reverse in statute is just the administrative work you just described of having some additional rules. I don't see another downside. While you're working on one, presumably if we pass them both, you'd just work on the other, and that would be a package. So it's not necessarily substantially greater work that we would have to be concerned about that.
I don't like to say don't pass the law because it creates more work. I'm okay with doing the work.
Okay, and the other thing, we could have a delayed effective date for it too, to give more time for it, but yeah. Okay. So kind of the same concerns overall in terms of that additional language on the capital requirements and working that out for next time. All right. I see that Caitlin has her hand up. Sorry, I missed you a second. I don't know how long you've had your hand up, but I see you now, Ms. Long. Floor is yours.
Thank you, Mr. Chairman, and thank you, Commissioner Bishop. Just making the committee aware that there is a new federal payments bank charter in the stablecoin bill. So if that does become law, there will be rules and capital requirements around that the industry is going to be thinking about in relation to speedy banks. And I do expect that some of the traditional banks, like for example, we know, for example, that Silvergate and Signature explored setting up speedy charters because they were functionally non-lending banks. Well, Silvergate was in particular. Towards the end, it really wasn't making many traditional loans and sold off its loan book and wanted to be effectively a speedy charter, right? So I think the only reason I'm flagging this is that something major is about to happen if the stablecoin bill becomes law that will have an impact, because there will be for the first time a federal non-lending bank charter. And we don't know what the impact of that will be on the industry yet. And we don't know what the capital requirements are. We don't even know if the Bank Holding Company Act and Community Reinvestment Act requirements are going to apply. There's just a lot of open questions at this point. Thank you.
Great. Thank you, Ms. Long. That's helpful. Appreciate that context. All right. Any further questions? Any further questions or discussion? Okay, seeing none, let's take our break now, and then we'll come back and take some action on it, which will probably be move it down the road. But let's take 10 minutes and come back around 10:45. And we're back from the break. So we were just discussing a couple of bill drafts related to conversion of Speedy Banks to state chartered banks, and back again. Committee on these two bills, I guess we should take other public comment. I don't think we've done that first. Is there, before we take any action, where we won't take final action, but any public comment on either bill draft 26 LSO 14 or 26 LSO 13 working drafts 0.4? Any public comment? Seeing none, public comments closed. Committee, what's your pleasure? I think based on testimony, we've got a couple of tweaks to make. I also think that these bills can be combined. I talked with the commissioner and he doesn't see any problems with combining them into one bill draft. So that makes life a little bit easier. One fewer bill draft that we have to take to the floor. So it would be my inclination, Mr. Co-Chairman, to combine the two bill drafts, have Mr. Bishop work with our staff to make those amended tweaks and then consider it either at the next meeting or at the following meeting for final disposition. How's that sound?
Mr. Chairman, I think that sounds great. I did want to ask Representative Filer what his thoughts were on this bill draft. Was this a amendment? This was similar to an amendment that we tried to run during the session. And I just wanted to get his thoughts.
Great. Representative Filer, thoughts?
Thanks, Mr. Chairman. It was an amendment that we tried to run. But I think maybe we ought to, just roll with the two as one, and then look at that amendment that we tried to run. I was trying to look that up earlier. Make sure we can incorporate that amendment with it, but it was a tough explanation in the House. There's many that just don't understand it. Eyes were glazed over. So any way that we could get better talking points, maybe bring it down a level as far as being able to present it.
Sure.
We want this to go through. But if, combining both bills into one would be a good start for one. But I think we should definitely move it forward.
Great. Mr. Co-Chairman? Subcommittee, anyone else have any thoughts on this? Without objection, we'll combine the drafts, make those amendments as suggested, and move it forward to one of the next two meetings. Any concerns? Going once, going twice, seeing no objection. Let's proceed accordingly. All right. Up next, we had just a little bit of a discussion, again, staying with Speedy Banks. Commissioner Bishop, if you want to come back up, we just had some discussion about bank certificate of authority process discussion for Speedies. I think this came up with the process that we put in statute, not having an in-between, or basically having a purgatory phase is kind of how I guess I'm interpreting it. And we don't have a lot of statute around how the commission manages that purgatory phase. So that's my understanding, but please proceed. What are your thoughts regarding Speedy Bank's certificate of authority process?
Yes, thank you, Mr. Chairman. Again, Jeremiah Bishop. This is something we've been discussing with all of our SPDIs, and then also especially with Matt Kaufman and his law firm. They represent some of them on this process. So what I want to do is kind of go over the current statute process, compare that to how we've been enforcing it, and seeing if there's needs to be maybe any tweaks on the law, or if we agree that the law is fine, we can tweak things on our end. So the statute we're discussing is 13-12-116. The certificate of authority to operate. So once an SPDI obtains the charter from the banking board, they must then receive the certificate of authority from our office before they can commence business. Once they have that, they can commence business in a certain time frame. I think where some of the disconnect is what should be in place before they receive that certificate of authority. So the current language in the law basically says the application should, include the address of the bank, the directors and the officers, and that's it. Once you have that in place, you can open for business, and hopefully you're doing it the right way. We didn't like that, obviously, so we did expand on what that certificate of authority requirement should be. So what we do is once an SBDI obtains their charter, we give them a requirements letter, things they must submit with that application for their certificate of authority, about 28 items, most of which are board certifications and resolutions. It's just the board certifies they will, not issue dividends in 3 years. They will notify us of any directors and officers change in 3 years. So mostly certifications. We just want that something in writing from that bank's board that yes, they will operate in a safe and sound manner for most of these items. However, some of them are a lot of work to be done. One of them is obviously paying in capital. I don't think you should open a bank without having sufficient capital day one. That's currently not in the law. It is in the law for traditional banks, and it is in the law for trust companies, but not for SPDIs. The language in those other two areas is that's part of the applications. You must certify you've paid in capital. That's one of the requirements we have on Speedies. That's just a good idea. One of the other things is, they have to have, other insurance items, but one of the one that takes a lot of work is called a core banking system. This is kind of your technology system that banks run on. It does everything from your accounting to your customer user interface to online banking to how do you access payments, whether it's through a master account, correspondent bank, or another bank. Without a core system, you really cannot operate as a bank. Not very well, not efficiently anyways. So that's one of the things is you must develop a core and you also must test it. This is a significant project for a bank. Because without this, again, it's very inefficient to run. So having the capital and having this core, I think, is one of the things that takes a long time to comply with. And so where we are at is we have some institutions now where they've received the charter and we've given them this requirements letter, and it's been 4 years and nothing's happened yet. So that's kind of this purgatory. So I think the discussion is just how can we avoid that? One process is we can just change our requirements and just follow the law exactly to the letter. In which case you can open once you certify that you have an address and that you have directors and officers. But there's no requirements that you open in a safe and sound manner. So then we'll send our exam team in 6 months, and we're already going to have significant issues from basically day one because you're not opening in a safe and sound manner. That's not a good way to get started. We could even pull the charter at that point if we feel like it was outrageously unsafe manner. We could do that. I don't think that's a good approach. I want to make sure that we're transparent with our requirements with these SPDIs and that they know what the rules are so that we can be on the same page. But that would be one way of doing it. Another way is we can say, hey, here's what you have to do to be in good standing with us. But here's your certificate of authority. Within the law, you have 6 months from getting that certificate to open. If you don't open, your charter is forfeit. So we could give them the certificate and then second, also give them this letter of things that you have to comply with before our exam team comes in. And if not, we'll put you on enforcement action and escalate things. That's a little bit better. It's a little bit more transparent. But again, I think some of this should be reviewed before you even commence business at all. A lot can happen in 6 months. Or we can kind of just tweak the law a little bit, I think, and add some of this. Some of the things I was thinking about was one, adding in capital. Traditional banks have to do this. Trust companies have to do this. I think it's fair to say you should not open an SPDI without the capital being paid in and provide proof of that. I think that's a fair thing to ask. So that would be an amendment that you could put into this. But also that 6-month timeline, this can be extended with an application to the banking board. The current law, it's pretty high level, just the banking board may extend. That's all it says. So if we make sure that, you have directors and officers, your capital's paid in, if there's anything else we need, like, policies, things like that's not onerous to comply with, that's fine. But it should be, you should be able to apply for this certificate pretty shortly after obtaining the charter. I think the intent was that you apply for this probably within several months, if even that long, from obtaining the charter. You should already have solicited capital. You should have shareholders. You get the charter, pay in the capital, and apply for the COA very shortly. But then you have 6 months to build out your core banking system. That's not a very long time. So again, I think what I would propose is maybe extending that to 12 months and then put a limit on that extension from the banking board, that you may make an application for an extension. They may extend it one time for up to 6 months. Again, I'm not tied to these timelines. I'm just throwing these out. I'd love some input from the SBDIs on what they think is an appropriate timeline. Then, okay, you have basically 18 months now to build out your core system and get it tested, get third-party contracts in place, and actually commence business. So if we make these changes, the timeline, then you get the charter, probably again, within 30 days, you should be making an application to us for a certificate of authority. I'd also like to put a timeline on that as well, just in case capital doesn't show up. If you have an investor that backs out once you get the charter, now you're back at square one raising capital. So maybe say you must apply for the certificate of authority within, again, I'm not tied to this, I'm just throwing this out there, 3 months of obtaining the charter. And if you don't, the charter is forfeit. Once you apply for the certificate, we'll give it to you. Now have 12 months to commence business in good faith or in a safe and sound manner. And then that can be extended 6 months with an application to the state banking board. Then we're not left with banks being in purgatory for years. That's not a good look for us. It's not a good look for the charter itself to have some of these companies out there for multiple years. Get the capital in place and have and get going quickly. That's the idea of this. And if things for some unknown reason fall apart after you get the charter, well, then maybe you should start over. If your investors back out, your board changes, your president leaves, at that point, it is no longer anything resembling what was approved by the banking board. So at that point, I think you should start over, surrender the charter, and reapply if needed. Hopefully that never happens, but this puts some very clear deadlines in place for the banks. It also kind of holds us a little bit more accountable. We can't just interpret an unclear law any way we wish. So anyway, that's the thoughts I had. I think it may be a good discussion topic. Love to hear from the SVDIs, Mr. Kaufman, see what their take is, just to put some clear deadlines in place, and also restrictions on us for what we should or shouldn't require to get through some of these steps.
All right. I have a quick question, then I'll get to the committee questions. One I have is clearly this is a different set of requirements than our traditional state chartered banks. Somehow we didn't really align those very well when we drafted this. What is missing from this that is provided for a state chartered bank for their certificate of authority? And could we just use that process?
Yes, thank you, Mr. Chairman. I think the biggest item that is different is the capital piece. I'm going through the difference. I mean, there's certify the address, adopt bylaws, identify directors and officers. That's for an SPDI. Traditional bank, certify that the capital and surplus have been paid in, and then you have bylaws, officers, directors, but then you also have that insurance piece that we kind of spoke of before. That would not apply. So really it's just adding in the capital must be paid in is the only difference. Now, I have never chartered a traditional bank. The last one chartered was, I think, 2006. So it's been a while. But the idea is similar. This should not take years to open once you obtain the charter. So I think adding in the capital piece, I think would align the two enough.
That's helpful. Thanks. Questions, subcommittee? Representative Filer, go ahead.
Thanks, Mr. Chairman. I was just wondering, because we're talking about speedies and then traditional banks and all the regulatories, the 28 things that, you're listing and some of the bigger ones that are hard, like capital, right? So we're talking about capital, and I understand on the banking side, on your traditional banks, why we have to have an abundance of capital, because you're going to be doing loans, you're going to be doing a lot of other things, where speedies are not allowed to do those types of activities just yet. So I think when we look at this, we don't want to hold a speedy bank from opening just because they don't have, well, one, your customer base, what you're allowed to do, how much capital you're actually going to need. There's a lot of different moving parts when it comes into making sure you have the correct capital when we do this. So, I think on the regulatory side, the way the law is written, like we just mentioned, or in all these other conditions, I think we have to really look at these conditions. This is not your standard charter bank. Getting capital might be a little bit harder. This is something new. I don't want to hold them up because, there's not a certain exact dollar amount just yet. What is that capital going to be? So I think we really got to look at that on the regulatory side, Mr. Chairman, that we don't hold these folks up. Traditional banks, it's a lot easier to get investors. It's a lot easier to, get capital, stuff like that. But, you can't just depend on your board members to throw in their own money or whatever that capital might be. So some of these regulatory things, I think we really have to look at is just as far as we don't stop these speedy banks from being able to operate because we're trying to make them a traditional bank.
Good point. Anyone else in the select committee? I'd like to hear from Mr. Kopp in a second, but I, would point out one of the challenges we obviously had with our first group. I mean, they couldn't get a routing number. They still can't get a master account. They probably had some challenges with some other things that ended up taking time that we didn't even necessarily hear about because they got resolved without legislation. And we still don't have, hopefully everyone's getting their routing numbers now, but we still can't get master accounts. So I know that struggle, or that's a challenge when your business plan relies on having a master account. You can't get one.
May I answer that real quick? One of the things is on our list is you must have a master account or correspondent bank account or some third-party bank account set up as part of that certificate of authority process. That is one of those 28 items that is holding people up.
Yeah.
So again, I agree. I think this first group, there was a lot of unforeseen things that came up, and I don't want to make this timeline so short that if something like that were to come up, they would have to forfeit the charter. That's not the intent here. But I also don't want it taking 4 years to open. That is a bad look for the charter as a whole. And then Representative Filer's comments on capital. That's one thing we struggle with is capital. Now, this is a bank. It is a bank charter. That is actually one of the bigger things about this is it is a bank, and so it must look like a bank. Now, it's not lending, so there's not that risk, but there's operational risk. There's cyber risk. I mean, every bank has cyber and IT risk. This one, I think it's more significant. There's a lot more, there's other risks. Now, we've very much struggled on how do you quantify the required capital. If you can come up with an equation on that, sell it and you'll make a lot of money. I've been trying to for lots of years. So if this charter is going to be taken seriously, the capital does need to look like a bank. And that's what we've done in the past. Otherwise, it's a money transmitter.
Sure. Okay. Thank you. Mr. Kaufman, I see you on. Let's give you a couple of minutes. I know you've been contemplating this as well.
Yeah, thank you, Mr. Chairman. Just a couple of thoughts, kind of a smattering of thoughts, really. I mean, first, it is tough because the window of time since the SBDIs, were first authorized and we saw the first 4 chartered. Obviously, there's been a tremendous amount of political movement and policy change federally, right? Which has introduced a lot of, whiplashing for these folks, kind of trying to balance both the market and, the sort of the regulatory picture. So I'm very sympathetic to that, and I don't want to, overreact to that. But on the other side of the coin, I totally understand and support where the commissioner is coming from as well. Again, the commissioner's in a tough spot on some of these applications because the commission has to, or the division, I should say, has to set the capital requirements that we're talking about. Well, a lot of times those capital requirements aren't really fully understood until pretty far into the process, right? And so that can pose a challenge both for the division, but also for the applicants as well, to kind of balance the timing of that capital, when that capital has to be placed, how they're going to approach investors and sources of capital and things like that. So I do think, having some amount of grace period in there that sort of balances both sides of that coin as best as we can is probably a smart policy. I would hate to see us, go too stark one way or the other, largely for the reason that we're still iterating, right? We're still figuring some of this out, and we're still kind of improving upon the process every time. So, yeah, I'll stop there, Mr. Chairman, if there's any questions, but very, very sympathetic to both sides on this.
Thank you, Mr. Kaufman. Appreciate that. Any questions for Mr. Kaufman at this point? Seeing none. Mr. Revel, I see you see your face right now, so that suggests that there went your hand. Okay. Floor is yours, sir.
Just raise your face. Thank you, Mr. Chairman. I want to voice my support here for what Mr. Kaufman just said as well. I think that while there needs to be a balance struck, given the uncertainty around some of the pieces that come into place, that agreeing with the commissioner, it's not a good look if we aren't moving the banks along. There needs to be something to move the speedies along or wind down if they aren't able to raise capital in a timely manner. And to the question that was raised about the state banking charter, I believe that the FDIC has time requirements to open within a certain amount of time once insurance is granted, and that's what sort of keeps the process moving along. And so absent that requirement with the speedy, we're sort of disconnected a little bit. But anyway, just largely voicing my support for the commissioner and Mr. Kaufman's views here.
Great. Thank you, Mr. Revel. Any questions for Joel? All right, seeing none, thanks. Select committee, anyone else have any questions or thoughts at this time? Anyone want to weigh in? We'll go to public comment in a second, but I just wanted to give everyone a chance. All right. Seeing none, let's go to public comment. And I see Julie's got her hand up, so let's start with you, Julie. Go ahead.
Yeah, I just wanted to make a comment about the timing and, in response to some of the concerns and the question around timing. I mean, one, I want to just ask the question. In my opinion, I don't think it is a quote unquote bad look for Wyoming to have entities that are in process but have not fully opened. I know that other states have processes where there's an annual certification, there's check-in, there's other requirements to keep it from being terminated, a certain type of licensure to be terminated. So I would ask that there be, some thought around that process. And I also think that, Mr. Kaufman mentioned the fact that the last several years have been quite a whirlwind in issues and changes that have all impacted the ability to raise capital. And many of them are federal issues. There were, FTX and other large things that happened, which made people, kind of back away, potential investors. And so I would say that there have been things that have happened. And so I don't know that putting a specific time limit at this point is the best way to manage this.
Thank you very much, Ms. Fellows. I appreciate that. Yeah, good points and good thoughts. Any questions for Ms. Fellows? Seeing none, thank you. Any other public comment? Any of our other speedies out there want to raise a hand. Please feel free if you want to weigh in. Obviously, this is something that you all know about. Seeing none. Okay, excellent. Thanks. So this is something that I think should take a look at. And, Mr. Co-Chairman, my inclination would be to put together yet another little working group, but get Mr. Kaufman, Mr. Bishop. I see Ms. Navas out there going like this. So Commissioner Navas and have Representative Filer lead that little working group to explore what the language should be tweaked to. And I guess I'd tack on one other potential responsibility for that bill, which we had the discussion about the 102%, that bonus reserve. Let's task that same group with that. And that's obviously just a delete amendment. So that's super easy. But if we're doing a bill draft, this would be an amendments bill draft for Speedy Bank amendments. And let's work out an amendments bill for Speedies that incorporates at least those two things and anything else it needs to. So Representative Filer, would you be willing to lead that effort? Yes. Excellent. I appreciate that. Select committee, anyone have any concerns with that? And does anyone else want to join it? If so, let me know or let Representative Filer know. I'm sure he'd appreciate the help, but we've got a good team there. Okay. Yep. Commissioner Navas, please. A little public comment here.
Thank you. Flavia Navis, I'm a commissioner with the Wyoming Stable Token Commission, but I'm here representing as an attorney in the state of Wyoming that supports chartering of SPDIs and other bank charters before the Division of Banking. And speaking more generally, in my experience working with the Conference State Bank Supervisors and their chartering process for banks in other states, the SPDI is a bank, as the commissioner referenced, although a narrow bank because it cannot engage in lending activity, but it is a bank. And there are processes in other states similar to what the commissioner referenced for the chartering process, as well as the certificate of authority and timelines for those, including reviews of where the charter holder is prior to operation, expectations setting in timelines, as well as what happens if those timelines are not met. That's what I believe the commissioner was referencing around the 12 months. And all these things are in line with what other states currently do in chartering of banks in their states. So I would welcome the participation in this working group to share my experience with other state banking divisions and how they have approached similar challenges. This is not just in Wyoming that this happens. You have other states where banks get chartered, but they struggle to operate depending on different reasons, and it could be a myriad of things. But I think providing clarity for the Speedies will make this charter stronger, more supported before federal banking regulators and other state banking regulators as well, and the overall community. Thank you.
Excellent. Thank you so much, Commissioner Navas. And, I hope the group obviously will reach out to Ms. Fellows and Mr. Slater, as well as Ms. Long and Mr. Reuter, to participate as well, as they see fit.
Mr. Chairman.
Yep, go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. It sounds like we got a dream team put together. And
good.
I look forward to seeing the work that comes out of it. And thank you, Representative Filer, for taking that on.
Oh, perfect. Thank you all. All right. Any further public comment, and hopefully not, on Speedy Banks at this time, so we can move on? Seeing none. All right. Public comments closed on Speedy Banks. Let's move on to our next topic, and we're going to have to expedite this topic, I think, because we've got some external testimony at 1:30 for the artificial intelligence. So we're back to Division of Banking. Let's get first an update on open banking, which I know can be relatively quick. Just where are we at with the federals?
Yes, thank you again, Jeremiah Bishop on open banking. So on the state side, as you know, I think the open banking law passed, I want to say 2 years ago. We did implement rules that went into effect last year. To date, none of our banks are utilizing open banking right now, so nothing's really been tested on what we've done at the state level. I think this is one of those things that it's out there. Once we get some feedback on how it's used or may be used, then we'll have a little bit more updates and we can maybe tweak the law or rules going forward. But so far, no activity on the state side of who's using this. On the federal side, this is the CFPB's 1033 rules. So they did finalize their rules. I think they issued them, I want to say October of 2024. They did go into effect, I think, January 17th of this year, which was an important date because it was prior to January 20th. Now, so they are in effect. However, there are multiple lawsuits, I think, going on challenging these rules, mostly from banking agencies. And then the CFPB in general it changes by the day what's going on with them. I mean, they have, there's a lot of things happening at the CFPB. We don't even know if they'll even be around in the future or what they will look like. They've drastically scaled back their scope of regulatory review to basically banks only, which is what the 1033 rule would implement. But yeah, there's a lot of uncertainty over these with the ongoing lawsuits, and then there's a lot of people are expecting that there will be an actual legislative review of those rules since it was prior to the new administration taking over. There could be a legal review by the legislature to see if they want to change, overturn, or repeal if anything around 1033. So there's a lot of uncertainty right now. So right now we're just sitting back and watching. If anything changes or becomes more certain, we can adapt as needed. But right now, I think I sit back and let's see how things settle down.
That sounds perfect. I think we're in a good position there. You know, our rule's in great shape, and I think it provides an opportunity, if so desired, for our state banks. Any questions on open banking? Questions on open banking? All right, seeing none. Next update. So financial technology sandbox revisions. Maybe we'll start with Mr. Kaufman and then go to Jeremiah. And I see, we will also have the Secretary of State, I believe, to provide some thoughts on whether that's being utilized through the Secretary of State's office. Recall, we passed this legislation quite a few years ago, I think 2019, maybe even before, and it provides an opportunity for the Division of Banking or the Secretary of State's office to offer flexibility for certain statutes that are allowed to be flexed if certain conditions are met. So, there's been discussion about potential revisions and expansion of this based on things other states have done. So we just wanted to have a quick discussion of it and see if we want to take it up. We've obviously got an awful lot of things on our plate, but just a quick discussion maybe and see if this is something where we want to do a bit of work. Mr. Kaufman?
Yeah, thank you, Mr. Chairman. And I'll be very brief. I mean, I think the committee all knows, this was an enthusiastic topic. What was it, 5 years ago when we took it up and looked at this. Disappointingly, in practice, it just really hasn't been used much. I can't speak for the division of the Secretary of State's office. I personally am not aware of anyone that has really successfully used the sandbox. And so part of I think the driving factor behind some of the conversation now is that we're seeing a little bit of a resurgence of states enacting sandbox bills, but not only enacting sandbox bills, really leaning into the reciprocity aspect of the sandbox bills. And speaking for myself personally, and my law firm, we've counseled many clients looking at the sandbox, and candidly, many of them ended up going elsewhere just because they don't want to be caught in essentially the smallest market in the United States, right? People wise, for the initial test of this whatever technology they're developing. So a lot of them have opted to go to places like Arizona or North Carolina or Utah, and so I don't know, that's led into some discussion about, is there something that we can do to make the sandbox more usable, more approachable, particularly from a reciprocity standpoint. I don't know that I personally have heard or experienced, many people come forward with specific ideas of how to expand the applicability of it. And I don't know that that's necessary. Some states, have education technology sandboxes. Some states have insurance technology sandboxes. So there are some other subject matters that states have pulled into. But what I most just wanted to kind of direct the committee's attention to is that, I mean, this thing, at least on its face, is an incredibly powerful tool that just in practice has not been very usable, which is a shame. And so I don't necessarily today have any specific statutory suggestions, but Mr. Chairman, if the committee so desires, would be happy to be part of a working group to look at some of the recent bill passages from other states and particularly the reciprocity focus the states are engaging in, to see if there's something that we can do to pull Wyoming into a more competitive position on this.
That's great. Thank you, Mr. Kaufman. Any questions for Mr. Kaufman on it? And, I think that's a good transition to Jeremiah. Have you had anyone really exploring the use of the sandbox in recent years or using it?
Yes, Mr. Chairman. We get about, I'd say, 4 to 5 inquiries per year. Nobody has successfully used it for any of our laws. Primarily, there's the 2 reasons why nobody successfully used it is, one, they have to be located in Wyoming. So we did get, I think, some people that were interested, but you have to be in Wyoming to use Wyoming sandbox. But the most common one is you have to have an innovative idea that our law is prohibiting you from enacting or using in a business sense. And generally, our laws are not that prohibitive. So I think that's the biggest one. Most of the inquiries we get is they don't want to be licensed, or they don't want to have capital, or it's usually the money transmitter is a lot of times is they just don't want to go through the process of getting a money transmitter license. They're eligible for it. It's not prohibiting them, except for you have to have a license to do money transmitter activity, but there's nothing innovative that's prohibiting them. They just don't want to go through the process. I think that's the most common one we get. It's like, no, you would qualify for the license. We would likely approve it. You have to, that process is there for a reason. And so it's not blocking the innovation. So that's the biggest one is we're just not that prohibitive with our laws.
Gotcha. Mr. Kaufman, do you know if anyone's using any of the other sandboxes? Because honestly, I haven't heard of anyone using other sandboxes either, but I haven't dug into it recently.
Are you talking about, Mr. Chairman, are you talking about the sandboxes that we have in Wyoming, or are you talking about other states?
Other states.
Yes, I am aware of some, but again, candidly, most of those projects that we've had some engagement with, to Commissioner Bishop's point, haven't really been on the banking regulated side. It's more been in the securities side, or some interesting accommodation from a corporate statute standpoint or something like that. That's been most of them. But again, like I said, not to repeat myself, but most of those that we have talked to have sort of recognized what Commissioner Bishop just said, that, well, we need to be in Wyoming to test this. It may be difficult to get the reciprocity we want. We don't want to go to the lowest populated state in the union, to do that, to get a 2-year test period. So they opt to go somewhere else. So,
right.
Yeah.
Okay. Excellent. Is Secretary Gray online? Okay. Let's bring Secretary Gray in and see if the Secretary of State's office has had any utilization of the sandbox.
Well, thank you,
Secretary
Mr.
Gray,
Chairman.
welcome. I can see you.
Yeah, you like all the paperwork? We're
Appreciate you
getting things done here. We're always very busy.
It looks good.
Thanks. Thank you, Mr. Chairman. Do you want me to start?
Yep, go ahead, Secretary. We were just really looking for kind of updates from you on whether anybody's using the financial technology sandbox and has made any applications to you, whether you see any clear changes that might provide benefits or anything that we should take into consideration as we recontemplate this topic.
Yeah, thank you, Mr. Chairman. We tout this program all the time. It's one that we continue to try to get the word out there about it. We have not received on the security side any financial technology sandbox applications. I think you'll see in the letter to CryptoFed, it was actually one of our suggestions in 23 for them to explore this program. I think some of the comments that were just heard, I definitely want to listen to those comments. Obviously, those are statutory revisions. And I do think there are some obstacles there. I think it's a little bit of a policy choice on whether we're going to insert those into the program or not. But I do think that that certainly is some of those comments that we just heard on residency are an obstacle. Now, the policy decision, I think, is one that there should be vigorous debate on. But there is no doubt in the conversations we've heard that is part of the discussion.
Great, thank you. And do you have any on the residency, right? We were careful about that. We didn't want to provide, when we were drafting it originally, a sandbox where somebody can just sort of use and abuse Wyoming a little bit, but not have any nexus with Wyoming. So we become their sandbox, but not their actual playground once they go into business. And so I don't know what the workaround is. Do you have any thoughts on that?
Mr. Chairman, I think that's why I've heard that, and obviously that's there, but I think that it's a policy choice, and I think you're right. I mean, as I think about as we have considered this bill in the past, that's the reason we put that in there. I think I was a member when this went through, and I'm not on board with changing it yet. I certainly think it's an important discussion to have, and I'm not opposed to having that discussion, but I think that is an obstacle. Anyone want to add anything on that? It's an obstacle, but the question of whether that's an obstacle that we want to have there, and I think there are good reasons to have it there.
Great, thanks. Appreciate that. Any questions for Secretary of State? All right, seeing none, thank you, Secretary. We appreciate you chiming in on this as well.
Thank you.
And we'll give this some thought. We'll touch base with you if we end up, trying to look for some revisions here.
Thank you.
All right, Jeremiah, any further thoughts? Okay, Mr. Kaufman, back to you. Any final thoughts? I mean, we might need to noodle on this and see if there's anything we can do. The reciprocity, we obviously have reciprocity built in. And certainly when we passed the bill originally, we had the strongest reciprocity provisions, but obviously things have changed and other states have passed it since that time. I don't know if we still have the strongest act. It definitely was the best fintech sandbox legislation that existed when we passed it. But probably 3 or 4 states have passed it since then. So do you know if we're behind anywhere? Do you know if other states put forward more aggressive? I don't think there's anything we can probably readily do about changing our population from 584,000 to 8 or 9 million. That would help.
Yeah, Mr. Chairman. So just a couple of parting thoughts on this. I mean, one, yes, some states have taken an approach to pass just general sandbox bills. And I know that's one of the things that's in the agenda today for discussion, which has broadened up, the applicability of the potential sandbox. To be perfectly honest, Mr. Chairman, I personally have mixed feelings on that approach. I think you're right, Mr. Chairman. When we first passed this, we were one of the more aggressive sandboxes at the time. Obviously, it was done kind of in conjunction with a lot of the suite of legislation we were passing around, enabling different blockchain applications. Which made a lot of sense at the time. If I was going to make any suggestion at this point, Mr. Chairman, and I'd be more than happy to take it upon myself to maybe have some conversations with the Secretary of State's office about this is just my observation, but I think most states have attempted to kind of capture those companies that want to utilize their sandbox and require them to be in state, right? And so when you have that competition among states, as I said, our population just, at least in my experience with a lot of these companies, has been a disadvantage. So maybe, and I'm not even necessarily putting this forth for the committee's consideration, but maybe in conjunction with the Division of Bank and the Secretary of State, we could brainstorm if it's worth bringing back to the committee, any ways to, again, readdress the reciprocity aspect, that if a company is utilizing a sandbox in another state, they don't want to relocate here, but we would love to see them domicile here, or whatever the case may be, that we could participate in that. Maybe there is a policy discussion to have there, but to me that is the low hanging fruit that has been the big barrier. So I'm more than happy to spend some time
Okay.
investigating that and having some discussions to see where that goes.
Yeah, that sounds good. And we do have, I don't think we'll dive into it. We have the bill draft for 24 LSO 95, which is the General Regulatory Sandbox program. And I think in the interest of time, we probably won't walk through it. It takes our financial technology sandbox and extends it very broadly throughout statute so that it applies to other provisions, one of which is insurance. And I do want to bring up our insurance commissioner and hear a little bit about the insurance side of it, which is an extension that I think when we looked at legislation several years ago, no state had implemented an insurance sandbox. But I think since we looked at that, states have done general regulatory sandboxes. So I think visiting on that would be good. But does anyone want to, and I'm really just trying to save a little bit of time ahead of lunch. Does anyone want to walk through the general regulatory sandbox program, Bill? I think we're all familiar with it because it was introduced in the last session. In fact, I think it was introduced, Mr. Co-Chairman, for about the last 2 sessions or 3 sessions. Does anyone need a background on that? Okay, so we're familiar with that. But I do want to go to public testimony on it and contemplate some of these other sandboxes. Mr. Root, if you or he's online, yeah. That's let's go to Mr. Root with our insurance commissioner. There he is. Mr. Root, I hopefully you've been listening to the conversation so far. We had a lot of discussion maybe 3 years ago on an insurance sandbox and worked through some legislation on that. At that point, I don't think there was another state that had a fully implemented insurance sandbox, but I know that you keep track of these sorts of things, and we've seen states with general regulatory sandboxes put into place. So has the industry changed the way that it is interacting with insurance sandboxes? Do you have any updates for us, or in general, what are your thoughts?
Mr. Chairman, again, it's Jeff Root with the Department of Insurance. There are approximately 8 or 9 states that either have a specific insurance sandbox or are covered by a general sandbox, like the bill that was contemplated in 2024. I called about half the states, and they said that none of the other. I'm sorry, I was making sure my mic wasn't double looping there for you. I found out that there have been no successful applications that have been approved. And I inquired as to why, and they said it goes back to the request really not, they're not asking for relief from an innovation. They just want to comply with existing regulation. And it wasn't an innovation issue, really. They just didn't want to post as much money or have surplus of a set amount. And that's really what we've heard all along. But at this point, that's where we are on the insurance side of the house.
Okay, thanks. And that's helpful. So we have seen this implemented. One of the concerns when we were looking at it, again, nobody had implemented it yet, was accreditation concerns for the state of Wyoming if we even implemented the legislation, that there might be NAIC concerns associated with that. Did that prove out to be something that came to fruition, where we had the accreditation, the insurance accreditation for states being threatened as they were passing their insurance sandboxes or their general sandboxes that allowed for insurance sandboxing?
Mr. Chairman, I recall one conversation with one state that said they did want some waiver of an NAIC provision, but once again, it wasn't a requirement because of their innovation that they were putting forward. It was just they didn't want to comply with the reporting requirements that any insurer could do, or post the funds that were needed to start up an insurance company.
Okay, so we're not really seeing any innovation. We had that bill and you were involved in the discussion on it where we were looking at alternative backing of an insurance where it was a whole life insurance that was being the assets were being brought in Bitcoin and would be paid out in Bitcoin, but the asset backing of the insurance policy would have to have been in dollars, even though Bitcoin was the matched asset. You know, that's the one I would say innovative type solution that we've seen where it might trigger innovation instead of just hey, we don't want to file our reports, or we don't want to comply with things we don't like. Do you think that that would fall under a sandbox, under the sandboxes that other states have put in place based on your understanding?
Mr. Chairman, I do not. When you look at our standards for a company and the assets they must maintain, there's requirements for diversification. And they can't have more than generally either 5 or 10% holding in any one asset. So, you know, they need to have that diversification so they have money available to pay claims. And in this instance, I recall that the company was 100% Bitcoin denominated. They weren't going to hold cash. They didn't want to hold cash. They didn't want to hold bonds or anything else. And that was the real problem. And so what they're being asked to waive were the core financial examination regulations, which all are NAIC standards.
Okay, understood. Thanks. Any questions for Commissioner Rood? Anyone online of the Select Committee? All right. Well, thank you, Commissioner Rood. Appreciate you joining us today virtually, and appreciate your testimony, clarification on that, and the update specifically that we've got 8 or 9 states that we can be watching for insurance sandboxes.
Thank you.
All right. Any other discussion on the general regulatory sandbox before we go to public comment? All right, let's go to public comment on the regulatory sandboxes. Do we have anybody that wants to provide public comment? Wow, they're trying to get us to lunch early. That's great. Public is being helpful right now. All right, let's close public comment. Back to the committee.
Mr. Chairman.
Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. I was working on a regulatory sandbox program bill for this last session, but I felt like I was throwing too many bills at the wall this time around. I had like 13 bills, and
that's a lot.
You know, maybe I shouldn't divide my attention like that. So I held back from introducing this bill. But I'm hearing from specifically folks from Utah that they're having a lot of success with their regulatory sandbox, especially in areas like housing. And so I think the idea is worth exploring. I did appreciate the term, we don't want people leaving the sandbox to go play in a playground, and the logic behind what was said earlier about, I mean, if we have a very business friendly environment in Wyoming, it's going to be more difficult for us to even utilize a sandbox. But I also think that it provides a mechanism for the public and the business community to report where there are inefficiencies in the rules that we have, and where we ought to rethink things in ways that wouldn't necessarily be directly reported by citizens or by individual legislators. So I think it does allow for us to at least hear where there could be changes to make Wyoming even more business friendly.
Yeah, good points. And I think about the risk that is taken if you need to sandbox something. You work through. You've got a business practice that you want to implement, and so you bring it to a state that has a sandbox, and you've got In Wyoming, it's 2 years with an opportunity to have a third year extension. Theoretically, though, at the end of that third year, if the legislature doesn't pass legislation, you have to shut down your business. So good luck bringing capital to that proposal. And I think that's probably been the proposal. And you know, Utah touts its sandbox, but I'd love to know how many people they've actually had use their sandbox. The success stories I've heard, honestly, were early on meetings with the Division of Banking where there was a desire to use the sandbox, and then the Division of Banking said, you don't have to use the sandbox. We have a regulatory structure for that. And then things just sort of work themselves out, conversations move forward. So I don't know. I mean, I don't know whether there are substantial success stories out there for other states building these sandboxes and implementing them. If there are, we want to position ourselves strongly, but I guess the question is, and maybe we look into this a little bit more, Utah did put together a pretty good piece of legislation that opens things up. Maybe we need to look into and explore who has used that and how, and did we miss an opportunity as a result of it? I don't know the answer. Other thoughts on this? How do we want to move forward on this? Leader Yin, what do you think?
Mr. Chairman, thank you. I think a general regulatory sandbox creates a situation where there could be ideas that are great and then are proposed to us, and maybe we will make law on them, or there could be a lot of ideas that are not so great. I worry about the breadth of a general one. I don't mind, let's come up with a housing regulatory sandbox or an insurance one. But that way we have specific focus, and then we know that the kind of output that comes from it will have the time and focus and energy to do it. I second the worry about what could happen is we could have a general regulatory sandbox. Companies come with ideas, they're good for 3 years. But because we never really had the focus in the legislature for that specific thing, they don't find a champion in the legislature to make sure what they wanted to do becomes law within 3 years, and then they're gone. I think if we have issues with the population concern, with the financial tech one, we're going to also find that becomes an issue with a lot of other situations as well. So what I would say is let's try to fix the one we have so people will actually want to use it. And once we have a good working situation with that one, then we can find some new areas to explore into.
Sounds good, Leader Yin. Representative Filer, what are your thoughts? Sure.
Well, Mr. Chairman, anything that's helps economic development, whether it be building anything with our communities, new business, any type of legislation that helps maybe deregulate some of those massive hurdles, I'm always in favor of. So, when we look at that kind of stuff, it's, like Representative Yin said, or Singh said, sorry, that happened to you twice today. Where he said there's probably some successes in Utah. I'd like to hear more about that. But I don't think we just throw it to the side. I think this is something we really have to, especially when there's a lot of legislators out there right now that are looking for deregulations on building departments and other things like that. This might help hold into that.
Leader Yin, I know that you do a lot of work on housing. Have you seen any housing regulation sandboxes around the country that seem to do anything?
Mr. Chairman, I have not, but there were ideas that came to us during our regulatory reduction task force that we ultimately didn't implement in the legislature. And so, there could be a worry as, do we build a building that we created within a sandbox, and then what do we do in 3 years if the sandbox expires?
That's
Does
a
that
good
become a
question.
problem?
Knock it down. Representative Fowler?
Mr. Chairman, I think maybe we can look at that and maybe if that 3-year worry is the hiccup, you know, because it's 2 years, then you can extend it a year.
Yeah.
So say we do build a building, right? Or somebody builds a building for, say, housing, apartments, whatever it might be. And that 3 years comes up, maybe we put a clause in there that, you know, if the project is complete or something like that, that we don't just say, oh, no, just tear it down and let's start over. There's got to be something that keeps that to where people are willing to invest, but or maybe sunset something to where we have to keep looking at the law. I don't know.
I think a lot of that, though, will come down to the innovation side where the project itself won't necessarily be innovative. The fact that they want relief from regulations because it decreases the cost of the project will be the motivation for wanting to be in the sandbox, which is not really the spirit of the sandbox. It's more the spirit of the regulatory task force of, you know, let's try and find areas where we can get rid of regulations. So what we've heard so far is that most of the people that come along, like Commissioner Bishop was talking about, they just don't want to have to do the regulations. And I think that, again, is probably also true with housing. Regulations are holding them back. They're not going to build a fancy new house that's innovative. Probably.
Mr. Chairman.
Yeah.
Thank you, Mr. Chairman. So I think just the concept of the sandbox itself is almost supposed to be temporary. So you exist in the sandbox and then until you have a resolution, you're existing in the sandbox. So you move to having something happen in the legislature to address the regulations that are going on. So if we were to implement some sort of sandbox program, unless there was some sort of report or account given to the legislature itself, we would end up in these hard 3-year situations because there's no communication happening between the entities that want the change and the entities that can make the change.
Yeah, I think that 3-year window really is a struggle for a capital investment. Unless you have a company, a large company that actually has like R&D where they can throw some dollars and check and see if something works. Let's see any hands up online for the rest of the select committee. Anyone else out in Zoomville want to share your thoughts?
Brendan.
We're good? All right. Well, I think here then we probably need to do just a little bit more exploring, find out what success stories might be out there, what types of sandboxes might be out there that could be successful. You know, are there housing regulation sandboxes that have worked well? Do we have any success stories for an insurance sandbox? According to Commissioner Root, it doesn't look like anyone's necessarily implemented that. So maybe we need to spend some more time noodling on solutions. And if anybody comes up with one, Mr. Co-Chairman, then we can potentially bring that forward at another meeting. All right. Without objection, let's do that. So we're 10 minutes early for lunch today. And with that, we are at recess until 1:30 when we'll start talking about some artificial intelligence governance. See y'all then.